We appreciate this. Yes, brother. Gowde.
My lord, and in an application, my lord, premature transfer, my lord, no stay is granted, my lord. I filed a writ petition. Kindly be listed.
Tuesday. Good morning.
I challenge the initiation of E.
2:30 ನಾವು ಇಲ್ಲ.
End of the list.
2:30 ಇಲ್ಲ. ಬೇರೆ
End of the list.
ಏನ್ ಅರ್ಜೆನ್ಸಿ?
I challenge the initiation of DE. Date is fixed, inquiry is commenced. Lord, however, Lord, the KT was pleased, Lord, did not grant ex parte interim order. After taking, Lord, more than 3-4 adjournments are given, state has not filed any objections. Now the matter listed on 2011 for final hearing.
2011.
The key is complete.
2011 ಅಂದ್ರೆ ಯಾವತ್ತಾಗ್ತದೆ? 19 ಹಾಕಿ. ಓಕೆ, sorry. Yes. Yes, brother.
Please.
2:30 ಈ ಬೆಂಚ್ ಇಲ್ಲೇ ಇಲ್ಲ. ಹಂಗೆ 1:30 ಭಾಳ ಅಂದ್ರೆ ಯಾವುದು? ಅದಂಗೆ ಪೆಂಡಿಂಗ್ ಮ್ಯಾಟರ್ ಅದು ನಂಗೆ 2:30 ತೊಳಿಗೆ ಬರ್ತದೆ. ನೆಕ್ಸ್ಟ್ ಡೇಟ್ ಅದ. ಯಾವುದೇ ಪೆಂಡಿಂಗ್ ಮ್ಯಾಟ್ರನ್ನ ಪೋಸ್ಟ್ ಮಾಡಿಕೊಳ್ಳಿಕ್ಕೆ ಚೀಫ್ ಜಸ್ಟಿಸ್ ಪರ್ಮಿಷನ್ ಬೇಕಾಗ್ತದೆ. ಯಾವುದೇ ನೋಟಿಸ್ ಆಗದ ಮ್ಯಾಟ್ರ್ ಇದ್ರೆ ವಿ ಕ್ಯಾನ್ ಹ್ಯಾವ್ at 2:30 that way. Don't waste time. Should read rules. ಅವಾಗ ಈ ಟೈಮ್ ಎಷ್ಟಾಗಲ್ಲ. Yes, next. Yes, Acharya.
Serial number 12, my lord.
12.
Yes, my lord. ASG has been directed to appear. Earlier, Mr. Nargun sir was appearing, my lord. Now, the ASG is, the Kamath is, my lord, for want of his success. 2 days, my lord, I made the 2 weeks accommodation.
12 ಅಲ್ಲ.
ಹೌದು, 12 ಅಲ್ಲಿ.
ಅನಂತ ಪದ್ಮನಾಭ ಬೆಟ್ಟ.
12, first list, my lord. B group battle. Acharya, ASG Kamath is appearing.
All right. Week after next.
Please, my lord. Great.
At the recruitment. Date ಹಾಕಿ ಕೊಟ್ಟಾರೆ.
Respondent has retired 10 years back.
ಈಗೇನು ತೊಂದರೆ ಆಗಿದೆ?
After retirement, punishment has been imposed, and it will not take more than 10 or 15 minutes. Just
ಅಲ್ಲೇ ನೋಡೋಣ. In the second week of January 26.
Please.
Next.
My lord,
25.
my lord, serial number 7.
Next.
My lord, serial number 7. I am appearing for appellant.
Serial number?
7. Praise for your time. Senior is out of
third
session.
week of ಏನೇನು ಇದೆ ಕಂಪ್ಲೇಂಟ್ಸ್ ಏನೇನೋ ಇದೆ ಅಲ್ಲ, ಕಂಡೋನೇಷನ್ ಆಫ್ ಡಿಲೇ ಏನೇನೋ ಇದೆ. ಪೆರಿಮಿಟ್ರಿ ಆರ್ಡರ್ ಆಗಿತ್ತಾ? ರಿಕಾಲ್ ಮಾಡಿದ್ರೆ ಆಯ್ತು ಆರ್ಡರ್ನ. ಅಪ್ಲಿಕೇಶನ್ ಅಲೋ ಮಾಡ್ಲಿಕ್ಕೆ ಅಬ್ಜೆಕ್ಷನ್ ಇದೆಯಾ? ನಿಮ್ಮ ಅಪ್ಲಿಕೇಶನ್
Senior submission ಮಾಡ್ತಾರೆ. He is out of station.
Proceed does not understand. Application in I number 1 of 2024 supported by 2023 ದಿವಸ ಏನೋ ಎಕ್ಸ್ಪ್ಲನೇಷನ್ ಏನಿದೆ, ಬಟ್ ಏನು ನಾವೇನು ಇಟ್ಕೊಂಡಿದ್ರೆ ಏನು ಡಿಸೈಡ್ ಮಾಡ್ತಿರ್ಲಿಲ್ಲ ಏನಿಲ್ಲ. 2013 ಹಂಗೆ ಇದಾವೆ. ವಿಲ್ ರಿಕಾಲ್ ದಟ್. ಇಟ್ಸ್ ನಾಟ್ ದಟ್ ಅದೇನು ಕಬರ್ಡ್ನಾಗ ಇರ್ತಿತ್ತು, ಕೋರ್ಟ್ ಕಬರ್ಡ್ನಾಗ ಅಷ್ಟೇ.
In fact, my lord, there is one more appeal. My lord, there is one more appeal which is filed by the KADB. Even that has been become DNP. We have to file recalling.
ನೀವು ಅದು ಮಾಡ್ಕೊಳ್ಳಿ. ಇದನ್ನಕ್ಕೂ ನಾವು ಏನು ಈಗ 2013 ಮ್ಯಾಟ್ರ್ ತೋತಾ ಇದ್ವಿ.
My lord,
ಇದೇನು ಡಿಸ್ಮಿಸ್ ಆಗ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಏನ್ ತಗೊಂಡು ಮುಗಿಸ್ತಿದ್ವಿ. ನಮ್ಮ ಸ್ಪೀಡ್ ನಮಗೆ ಗೊತ್ತಿದೆ
I
ಏನು ಅಂತ
understand.
ಅನ್ಕೊಂಡು ಬಹಳ ಅಂದ್ರೆ ಅಲ್ಲಿ ಇರ್ತಿತ್ತು.
I understand.
ಅದನ್ನೆಲ್ಲ ಹೇಳ್ಬೇಕು, ಅದು ಕಂಪ್ಲೈ ಮಾಡಿಕೊಳ್ಳಿ. ಮಾಡೋಣ. ಒಂದು 4-5 ಪುಸ್ತಕ ಕೊಟ್ಬಿಡಿ. ಹೋಮರ್ HOMER ಹೋಮರ್ ಬೈ ಅರ್ಜುನ್ ಭಾರದ್ವಾಜ್. ಚೆನ್ನಾಗಿದೆ ಇದು. ಇಲಿಯಡ್, ಒಡಿಸ್ಸಿ ಮತ್ತು ನಮ್ಮ ಮಹಾಭಾರತ ರಾಮಾಯಣನ ಅದರಲ್ಲಿ ಛಂದೋಶಾಸ್ತ್ರ ಹೆಂಗೆ ಆಪರೇಟ್ ಆಗ್ತದೆ ಅನ್ನೋಕ್ಕೂ ಬರ್ದಾರೆ. ಇದು ಗ್ರೇಟ್ ಸ್ಕಾಲರ್ ನೋಡಿ. ಒಂದ್ಸರಿ ಸ್ಟೂಡೆಂಟ್ ಆಫ್ ಆರ್ ಗಣೇಶ್ ಶತಾವಧಾನಿ ಅವರ ಸ್ಟೂಡೆಂಟ್ ಅಂಡ್ ಡೆಡಿಕೇಟೆಡ್ ಟು ಭೈರಪ್ಪ. ಬುಕ್ ಈಸ್ ಡೆಡಿಕೇಟೆಡ್ ಟು ಭೈರಪ್ಪ. DVG ಗ್ರೇಟ್ ಸ್ಕಾಲರ್ಸು ಎಲ್ಲರದ್ದು ಇದೆ. The appeal was dismissed by the peremptory order dated 4/7/2018 on the ground that the valuation of subject matter of the appeal was not specified. First off, ideally speaking, it ought to have been. First off, the counsel for the applicant submits that the appeal has got merits and therefore if one more opportunity is given, the office requirement would be met. First up. Application is supported by an affidavit and no objections are filed to the same.
Please.
First up. Arithmetically speaking, comma, delay appears to be too long, comma. However, regarding head to the pendency of older matters, comma, it is not that this appeal would have been heard and decided soon after it was filed. First, at least the appeal papers would have been languishing in the cupboards of the court. First, in the above circumstances, application having been favored, the peremptory order dated 4/7/2018 stands recalled, and as a consequence, appeal is restored to the board, subject to two conditions. Small one, the appellant shall present 2 books by Arjun Bharadwaj, inverts commonly, Homer, to the Advocates Association Library, and 2 books to the Judges Library within 2 weeks. Next point. Above apart, he has to comply with the office objections, again within 10 days. 10 days, comma, failing which the order now made stands automatically rescinded, and as a consequence, peremptory order revives as phoenix. Okay. Okay.
Obliged.
Much obliged.
My lord, back
Yes, Mr.
surprise to fixation of pay of the inspectors, my lord, on their promotion.
Ah,
My lord, here,
ready.
They
Hello,
have been-
we are for the respondents, my lord, 1 to 5, and we have, due to oversight, we have
One.
filed only one set of objections, my lord. And we have already filed second set, my lord. Needful has been done.
Second set you have to file. Don't worry, we will share the one set of objection between us. You argue.
We have already filed, my lord.
Huh?
We have already filed.
You have filed.
Yeah.
Argue then. Don't you need permission of your sister? All right. In the second week of January, we'll have.
we will.
Second week of January at the request of. First, counsel for the respondent submits that the second set of statement of objections is already filed. First up, registry to look into. Next.
Appear for the petition.
Ayan Prithvi.
Let's,
For
the
respondent
last
to the-
occasion, your lordship.
Huh?
Your lordships had heard this matter and posted it. Matter lies in a very short compass pertaining to transfer.
Ah,
The applicant, my lords, is
ready. Ready? Ready.
very,
Pudam. Pututai. Yes.
the applicant is a assistant executive engineer working under Rule 32, my lords.
Rule 32.
Rule 32.
Independent charge.
Independent charge. My lords, I was posted to the respondent's place. Respondent had completed his tenure, my lords, in the year 2023. So he left the place for me. 2024,
Transfer applies, transfer guidelines apply.
please,
Even when you do not hold lien to the post in question,
please. My lords.
is it?
My lords, yeah, that is the only question, my lords, that is before your lordship.
How the courts have treated that question?
My lords, the court generally have held, my lords, that a Rule 32 employee cannot displace a regular employee.
Correct.
My lords, now, my lords, in this case, what has happened is, my lords, I am placed under Rule 32 for the reason, my lords, that certain matters are pending before your lordship pertaining to trifurcation. Your lordships, my lords, have permitted only for in-charge arrangement. Because of which, my lords, I am posted on in-charge arrangement. I was posted.
How long you have been there?
My lords, I have 2023, my lords, I went to the respondent's place. He was working there. I went to his place. Now this year, my lords, he comes back and displaces me, and tribunal says you are a Rule 32, you have to make way. My submissions, my lords, are
He
two.
is not Rule 32.
He is their substantive holder, my lords. He, my lords, vacated the place for me. Year later, my lords, he comes back to the same place and now I am disturbed, my lords.
Earlier, how many years he was there in that?
My lords, he has completed his tenure for about 4 years in the very same place earlier. Now, my lords, again, he has come back to the very same place. My lords, I raised the contention before the tribunal, my lords. Even though I'm Rule 32, only one aspect which may require your lordship's attention would be, my lords. I would fall within the categories of A, B, C, or D. Group A, B, C, or D, my lords.
Yenadu?
Under the transfer guidelines, the civil services is divided into 4 parts: Group A, Group B, Group C, and Group D, my lord. Now, I would fall within one of these categories. All these categories have the security of a tenure, my lord. Now, government, my lord, wants to place me on the higher post because there is deficiency of personnel. I am placed. Because of your lordship's order, my lords, I am under Rule 32. Now, my lord, that security of tenure, my lords, is taken away. Even though I belong to one of these categories, even if I was in the lower post, my lords, I had a security of tenure.
ಈ question answer ಮಾಡಿಲ್ಲ
No,
no
ma'am.
no judges have.
No courts have answered whether security of tenure. They have held, my lords, Rule 32, you have no security of tenure. But the question, my lords, would be, would I fall outside the limits of this Group A, Group C, or Group D?
ಅಲ್ಲ ಆ ಕ್ವಶನ್ ಹೇಳೋದು ಸೆಕ್ಯೂರಿಟಿ ಆಫ್ ಟೆನ್ಯೂರ್ ಇದ್ದಾಗ ಅಂತ.
Yes, my lord. No, my lord.
ಅದು ABCD ಅಲ್ಲಿ ಇದ್ದೇ ಇರ್ತೀರಿ ನೀವು.
Yes, my lord.
There is no answer.
Therefore, my lords, I am entitled to one tenure. Even if I am in the lower post, I am entitled to a tenure. My substantive cadre. Government wants me in the higher post, but does not, my lords, want to extend the benefit of tenure.
How tribunal has reasoned?
My lords, tribunal has only held, my lords, that since you are a Rule 32, you have no tenure, my lords. The findings would start. Your lordships will find the findings, my lords, at page number, paragraph number 7, page number 42, my lords. Para 6, I'm so sorry. The tribunal says you are only a Rule 32, therefore.
ಅಲ್ಲ how this question is not considered by
No.
ಸಮರಾದಿತ್ಯ ಪಾಲು
No.
ಇದರೆಲ್ಲ ಯಾರು ಮಾಡಿಲ್ವಾ?
Peculiar fact should be, while I am placed under Rule 32, the order itself would show, because of the pendency of litigation before the tribunal and the High Court, and the High Court has permitted only for in charge, we are placing you only on in charge basis.
Which otherwise you would have been
Please,
promoted to.
I am entitled to a regular.
ಅಲ್ಲ Rule 32, the one condition is that you should be eligible to be promoted.
Yes.
Therefore,
Yes.
argument ನಿಮ್ಗೆ.
ಇನ್ಚಾರ್ಜ್ ಇದ್ರೆ ಅದು 6 months ಮಾತ್ರ ಸ್ವಾಮಿ. ಮ್ಯಾಕ್ಸಿಮಮ್ ಪೀರಿಯಡ್ ಇಸ್ ಫಾರ್ 6 months. Rule 32 ಇನ್ಚಾರ್ಜ್ ಇದ್ರೆ. So tenure is not applicable to you.
That is held by the tribunal, my lord.
The maximum tenure of independent charge in charge judgment ಯಾವುದು? ಎಷ್ಟು?
32 is 6 months, your lords.
Only 6 months.
6 months.
Rule 32, my lord, would say the secretary up till the government, my lord, the head of the department can extend it up to 6 months. Beyond a period of 6 months, my lord, my Rule 32 order is 11/7/23.
11/7/23.
Yes, my lord. Even under the impugned order, I am posted as assistant executive engineer. My lord, if they had revoked my Rule 32 and posted me to a lower cadre, my lord, their argument that you are entitled to only 6 months, therefore you can't continue as AEE can be admitted, my lord. But here, under the impugned order also, I am posted as AEE. They continue me as AEE, my lord. That is not under dispute at all.
That benefit is extended to her. She should be happy. Lordship may kindly see, if she has continued in a lower grade, lower cadre, that would have been for her own disadvantage.
At least I'll have
Cannot be the reason. Lordship may kindly say, when regular post is available in Lordship, he has been
ಎಷ್ಟು
replaced.
ಯಾವ ಊರಿಗೆ ಮಾಡ್ಯಾರ ನಿಮ್ಮನ್ನ?
my lord,
ಅಲ್ಲೇ ಸೇಮ್
my lord,
ಅಲ್ಲೇನೆ.
within Bangalore. He was working in
Bangalore.
Bangalore in the next building. He was posted to my place. I am posted to his place.
See, ನಮ್ಗೆ ಅಷ್ಟೊಂದು
My lord, my
should have so much attachment
yes,
to that
my lord, I am
particular
not,
place.
my lord, on that. My only, my lord, agitation before your lordship was.
ಅಲ್ಲಿ ರೂಲ್ಸ್ ಅಲ್ಲಿ
Yes,
ಪೋಸ್ಟ್ ತೆಗೆದು ಪ್ಲೇಸ್ ಮಾಡ್ಯಾರ ಈಗ.
yes, my lord. That's my submission. That's what I want.
ನೋ ದಟ್ ಗೋಸ್ ಅಗೇನ್ಸ್ಟ್ ಯು ಅಂತ.
My lord,
ಪ್ಲೇಸ್ ಅಂದ್ರೆ ಏನು?
my lord, I am entitled to a security of tenure, my lord,
At a place.
at a place.
Yes, place. Bangalore retained as it is. Not post.
what your
Read the
lordship-
rules.
Yes, ma'am.
Rule 25, say 26-4, 25-6 or
25 minutes.
25-6.
Judgment is.
ಎಲ್ಲೋ ನಾವು ಒಂದ್ ಕಡೆ ಕನ್ಸಿಡರ್ ಮಾಡಿದ್ವಲ್ಲ, ಲಿಟಲ್, ನಾಟ್ ಮಚ್, ಬಿಕಾಸ್ ಮಾರ್ಜಿನಲಿ ದಟ್ ಕ್ವಶನ್ ಅರೋಸ್ ಬಿಫೋರ್ ಅಸ್.
Yes, my lord.
ಯಾವ್ದು?
In that. Your lordship's judgment, my lords, the recent decision. May I just place it on record? I'm sorry, my lord. I had a copy of it. I seem.
What do
to
you
have
say,
missed it.
Mr. Gowle?
My lord, so far as tenure is concerned, my lord, this honorable court has the tribunal, my lord, at page 45,
Therefore,
my lord,
easier.
down bottom.
Therefore easier.
Tenure ಪ್ರಶ್ನೆ ಬರೋದೇ ಇಲ್ಲ ಅಂತ ಬರೆದಿದ್ದಾರೆ.
ಅದೇ ಅವ್ರು ಬರ್ತಾರೆ, ಅದಕ್ಕೆ ಇಲ್ಲಿದ್ದಾರೆ.
ಅಲ್ಲ tenure,
Thank justify-
ಅಲ್ಲ, there is a order of the tribunal, my lord. In Rajshekar's case, there is a page 46 itself, he cannot claim any tenurial benefits under the transfer guidelines, which is for a government servants who are substantially more in the cadre and have a lien on the post in the cadre. Persons without a lien in a post in a cadre cannot claim any tenurial rights to a post in the cadre.
Too broad a proposition. Every month ಒಂದೊಂದ್ ಕಡೆ ಕಳ್ಸೋದ್ ಕೂತ್ಕೊಂಡ್ರೆ ನಾವು
ಇಲ್ಲ, ಇಲ್ಲ.
ಈ ಪ್ರಪೋಸಿಷನ್ ಮೇಲೆ
ಅಲ್ಲ, lower post ಇದ್ರೆ ಅವರು they can definitely complain.
ಟ್ರಾನ್ಸ್ಫರ್ನಾಗೆ ಲೋವರ್ ಪೋಸ್ಟ್ ಅಂತ ಪ್ರಶ್ನೆ ಬರೋದೇ ಇಲ್ಲ.
Anyway, my lord,
What your
anyway, my lord,
lordship
he is
held was-
continued in the same place, the same
Assume for a
building.
moment,
Where did the judgment?
Assume for a
Just see the
moment.
judgment.
every end of the calendar month, he will be issued another order. Go to Gulbarga, go to Belgaum, Bangalore, Bidar.
ಅಲ್ವಾ? State of-
Like this, it goes on. You mean to say? the
ಅಲ್ಲ, ಅಲ್ಲಿ
report only,
independent,
just
lower
watch
post
it as a
ಇದ್ರೆ he can
spectator.
complain.
Huh?
Lower post ಇದ್ರೆ he can complain.
But
But
ಈಗ
not
ಅದೇ
in a-
ಪೋಸ್ಟ್ ಅಂತ ಇಟ್ಕೊಳ್ಳಿ.
Pardon me.
ಅದೇ ಪೋಸ್ಟ್ ನಲ್ಲಿ ಎವ್ರಿ ಮಂತ್ ಅವ್ರನ್ನ ಟ್ರಾನ್ಸ್ಫರ್ ಮಾಡ್ತಾರೆ. You mean to say the writ court should be only a mute spectator to all that?
No, no, no. Here, my lord, he is not holding a substantive.
You have said that. ಅದನ್ನ ಬಿಟ್ಕೊಂಡು ಏನಾದ್ರು ಇದ್ರೆ ಹೇಳಿ ಬೇರೆ.
He is not.
Add to the jurisprudence of the judgment. ಅದು ಲಾಯರ್ ಕಿ. ಅದ್ರಾಗಿರೋದೇನೋ that is put in challenge. Therefore, he is here now.
ಇಲ್ಲ,
What is
that
your
is not
contribution
challenge,
to intellectual contribution in argument ನಲ್ಲಿ?
That is
ಎಂತ
not
ಬೇಕಾದ್ರೆ
challenge.
except saying.
Last occasion, he said that he has got the benefit of tenure. That's how, my lord, this honorable court called upon. There is no amendment to any of the rules.
Oh, that's happened.
And moreover, the
All the petitions. Several factors. A host of factors.
same building ನಲ್ಲಿ ಇದ್ದಾರೆ. ಈಗ same building ನಲ್ಲೇ he has been allowed to continue.
He was also.
ಅದ್ಯಾವ್ದು read the amendment.
May I just read, man? The vehement submission of learned so-and-so appearing for the textual change brought about to the transfer guidelines by government order dated so-and-so by substituting the expression minimum period of stay at a place for the term minimum period of stay in a post would come to the rescue of his client is difficult to countenance. Your lordship said it is the minimum period in the post and not the place. That is the substitution. I'm sorry, my lord, I only have a soft copy. Would your lordship? I'll place on record this judgment by Tuesday, my lord.
ಏನದು ಇಷ್ಟೇ ನಾವೇ ಬರ್ತೀವಿ
Yes, ma'am.
judgment.
Yes, ma'am.
We
Your lordship,
remember
sir.
every word of.
Yes.
But what prejudice has been caused, Your Honor? No prejudice is caused.
My lord,
ಏನ್
it's-
prejudice ಇದೆ?
Absolutely
So
no
far as,
prejudice.
my lord, may I say this, in so far as the facts and circumstances of this.
ಎಷ್ಟು
case,
ದೂರ ಆಗ್ತದೆ ಆಫೀಸು?
ಪಕ್ಕದ
ಏನ್
office,
ಬಿಡುತ್ತೆ?
ಅವ್ರು ಅಲ್ಲೇ
ಅಲ್ಲೇ, ಅಲ್ಲೇ.
even if your lordships were to allow my writ, my lords, he will remain in the same building, I will remain in the same building. No hardship in so far as both of us. But in
ನಿಮ್ದು
so,
ತೋರಿಸಿ ಅವ್ರಿಗೆ ಬಿಡಿ.
yes, my lord.
ಹಾರ್ಡ್ಶಿಪ್ ನಿಮ್ಗೆ ತೋರಿಸಿ.
Yes, no, my lord, in so far as hardship, my lord, I must say absolutely no hardship, my lord, in the peculiar facts of the case. But what your lordships may, my lord, my only insist, he was there, my lord, for 4 years. In a year, he comes back. My lord, that would be one
ಏನ್
circumstance.
ಮಾಡಕ್ಕೆ ಗವರ್ಮೆಂಟ್ ಪ್ರೊರಗೇಟಿವ್ ಎಲ್ಲ ಅವು.
That's right, my lord.
ನಾವೇನ್
My lord,
ಮಾಡ್ಲಿಕ್ಕೆ?
second is, my lord, in so far as, my lord, rule 32 and a regular, now, my lord, whether, my lord, that question would arise.
ಮಾಡಿಬಿಡ್ತೇವೆ ಈಗ.
Very grateful, but that's,
ಬರ್ಕಳಿ.
yes.
The civil servant is grieving before the Red Court against the State Administrative Tribunal's order dated 19, ಕೂತ್ಕೊಳ್ಳಿ. 19/9/2024, whereby her application number 3900 of 2024 came to be negatived. First off, in the said application, she had called in question a transfer order dated 31/7/2024, a copy of which avails at Annexure A5. And it has been issued by the first respondent. Semicolon. As a consequence, the third respondent is occupying the post which the petitioner had held. First, next paragraph. Learned counsel appearing for the petitioner vehemently argues that the tribunal denied relief against the said transfer on a wrong premise that 25/4/6.
25/6.
The government order dated 25/6/2024 promulgating the guidelines does not apply to the cases wherein the transferred employee lacks lien to the post which he held under Rule 32 of KCSR. First, in support of his submission, he brings to our notice our own decision in so and so decided on such and such date. First, he also adds that the third respondent was there in the said post for a period of 4 years earlier, and somehow he wants to cling on to the said post, and therefore he is displacing the petitioner. First off. So arguing, he seeks allowing of the writ petition. Next. Learned AGA appearing for the official respondents, and the learned counsel appearing for the private third respondent oppose the petition, making submission in justification of the reasons on which the impugned order of the tribunal has been constructed. First off. Learned private counsel submits that the reasoning of the tribunal as reflected in paragraph 8 of the impugned order is not alterable, and the same sounds to the rules of reason and logic. First, lastly, both they contend that the place to which the petitioner has been now shifted by virtue of the government order is in the building, in the neighboring building, in the neighboring building.
Same building.
Same building.
Same building.
In the very same building. Okay. In the floor change ಆಗಿದೆಯಾ, another floor ಆಗಿದೆ. In the same building, and therefore the elements of hardship which ordinarily the writ courts would have focal point at are lacking. First, so contending, they seek dismissal of the writ petition. Next one. Having heard the learned counsel for the parties and having perused the petition papers, we are broadly in agreement with the submission. Yeah, submission of the counsel advocates appearing for the respondents, that ordinarily transfer guidelines of the kind are not invocable by an employee who holds the post on in charge stroke independent charge, and that they are under Rule 32 of KCS. First up. they quote what Justice Ramajoy says in his famous book, The Services Under the State. At page 300, and we have quoted that book, this one in that also.
Yes. No, my lord, your lordships have not.
But next paragraph. It hardly needs to be reiterated that the terms in charge and independent charge arrangements are not unknown to service jurisprudence. Semicolon. They are occasioned, such arrangements are occasioned by the exigencies of service. Semicolon. The persons who hold the post on in charge or independent charge do not have right of lien to the position, and that they cannot exercise any substantive power of the said post as held by a learned single judge of this court in Basavaraj Dhotra versus Karnataka Land Army Corporation, ILR
2006, my lord.
2006 Karnataka, so and so, so and so.
3163, my lord.
3163. 3163. First off, we are also told that this view has been accepted by the other coordinate benches of this court. First off, that being the position, we do not find that the tribunal has committed any error, much less substantial. First off, next paragraph. The vehement submission of learned counsel appearing for the petitioner that the 2026 transfer guidelines employ the expression, employ the idea of a change of place, and that the same has been construed by this court in the case of
Shri Amaresh versus State of Karnataka.
Shri Amaresh versus State of Karnataka, WP number
24945 of 24.
24945 of 2024, decided by us on
24th of October 2020.
24th of October 2024, and submits that that view comes to the aid of his client. Aid of his client. First off, this aspect need not be examined deeply, since the case absolutely lacks any elements of hardship. First off, in any transfer, elements of hardship are one of the focal points of writ courts or the tribunal which shares the writ power. First off, such a view gains support from the decision of Apex Court in Varadharao versus State of Karnataka. AIR 95 SC so and so not comparing.
1986 4 SCC 131.
1986 4 SCC 131.
Please.
131. First, ನಮ್ಮ ILR ಏನದು?
Uh,
ಎಷ್ಟು ಚಂದ ಬರ್ದ ಜಸ್ಟಿಸ್ ಎಸ್ ವೆಂಕಟರಾಮಯ್ಯನವ್ರ ಜಡ್ಜ್ಮೆಂಟ್ ಅದು.
That road.
Next paragraph. In the above circumstances, this petition being devoid of merits is liable to be and accordingly rejected. Courts having been made easy. Space number ಕೊಡಬೇಕು.
Please. Yes. Great.
Yes.
I have translated copy, I may permitted to file, my lord, within.
Yeah, translated copy.
My lord.
ನಮ್ ಕನ್ನಡ ಬರ್ತದೆ.
Please.
Translation dispense.
dispense.
Argument.
My lord, the petition is initially appointed as a constable. Thereafter, he is promoted as thereafter he has promoted as head constable, my lord, in the year 2009. Thereafter, my lord, on 7/5/2021, after my lord, he has completed service 29 years. One incident took place, my lord, he was abusing vulgar language against the, my lord, traffic police, while the minister, my lord,
just incidents ಬೇಕು. There is one shairi by ಯಾರು famous Halib. हजारों फूल कम है एक दुल्हन को सजाने, एक फूल काफी है एक अर्थी को बुझाने. Like that, one incident will be sufficient.
my lord, but my lord, it is not at the time of the duty, my lord, by coming back with the exchange of words has been taken place.
ಅದಕ್ಕೆ ಎಕ್ಸ್ಚೇಂಜ್ ಮತ್ತೆ ಎಲ್ಲ ಎಕ್ಸ್ಚೇಂಜ್ ಆಫ್ ವರ್ಡ್ಸ್ ಎಕ್ಸ್ಚೇಂಜ್ ಆಫ್ ವರ್ಡ್ಸ್ ಏನ್ ಡಿಫ್ರೆನ್ಸ್ ಇದೆ? ಎರಡು ಯುದ್ಧನೇ ಅವು, ಒಂದಲ್ಲ ಒಂದ್ ರೀತಿ.
Sorry, my lord,
ಏನು
not,
ಏನಿಲ್ಲ.
thereafter, my lord, he has requested, my lord,
ಏನು ಪನಿಷ್ಮೆಂಟ್ ಏನು?
punishment, my lord, initially he was suspended. After, my lord, enquiry, he was being dismissal from the service, my lord.
ಏನು ವರ್ಡ್ಸ್ ಏನು ಮಾತಾಡಿದ್ದು?
My lord, at, my lord, enquiry report at
ನಾವು
73.
ಕೇಳ್ರಿ, ನಾವು ಕೇಳ್ತಾ ಇರೋದು ಎನ್ಕ್ವೈರಿ ರಿಪೋರ್ಟ್ ಏನಂತ ಅಂದ್ರು ಅನ್ನೋದು ಹೇಳಿ. ಎಂತ ಶಬ್ದ
My lord, at page number 75.
ಶಬ್ದ ಸಫಲ.
ಆರೋಪಣೆಗೆ ಸಂಬಂಧ ದಿನಾಂಕ 7/5/21 ಸಂಜೆ ಸುಮಾರು 6:30 ಗಂಟೆ ಸಮಯದಲ್ಲಿ ಚಿಕ್ಕಬಳ್ಳಾಪುರ ನಗರಕ್ಕೆ ಮಾನ್ಯ ಜಿಲ್ಲಾ ಉಸ್ತುವಾರಿ ಸಚಿವರು ಭೇಟಿ ನೀಡುತ್ತಿರುವ ಸಮಯದಲ್ಲಿ ಶಿಡ್ಲಘಟ್ಟ ವೃತ್ತದಲ್ಲಿ PS ರವರ ವಾಹನ ಚಾಲಕ ಕರ್ತವ್ಯ ನಿರ್ವಹಿಸುತ್ತಿದ್ದಾಗ ESC ಅನಂತ್ ಶಿವಾನಂದ್ ಅವರು ದಾರಿ ಮಾರ್ಗಕ್ಕೆ ಅಡ್ಡವಾಗಿ ದ್ವಿಚಕ್ರ ವಾಹನದಲ್ಲಿ ಬಂದಿದ್ದು PSI ರವರು ಈ ಮಾರ್ಗದಲ್ಲಿ ಜಿಲ್ಲಾ ಉಸ್ತುವಾರಿ ಸಚಿವರ ಕಾನ್ವೆ ಬರುತ್ತದೆ, ಈ ಕಡೆ ಬರಬೇಡ ಹೋಗು ಎಂದು ಸೂಚಿಸಿದರು. ಸಹ ಅವರೊಂದಿಗೆ ಗಲಾಟೆ ಮಾಡಿಕೊಳ್ಳುತ್ತಿದ್ದು ಆಗ ಅಲ್ಲಿಯೇ ಬಂದೋಬಸ್ತ್ ಕರ್ತವ್ಯ ನಿರ್ವಹಿಸಿದ್ದ ಪೊಲೀಸ್ ಅಧಿಕಾರಿ ಮತ್ತು ಸಿಬ್ಬಂದಿಗಳೊಂದಿಗೆ ಸೇರಿಕೊಂಡು ಅವರನ್ನು ಪಕ್ಕಕ್ಕೆ ಕಳಿಸುವ ಬಗ್ಗೆ ನುಡಿಯುತ್ತಿರುತ್ತಾರೆ. ನಂತರ ಆರೋಪಣೆಗೆ ಸಂಬಂಧಿಸಿದಂತೆ ಮಾನ್ಯ ಚಿಕ್ಕಬಳ್ಳಾಪುರ ಜಿಲ್ಲಾ ಉಸ್ತುವಾರಿ ಸಚಿವರು ಚಿಕ್ಕಬಳ್ಳಾಪುರ ಎಲ್ಲಾ ಆಸ್ಪತ್ರೆ ಭೇಟಿ ಕಾರ್ಯಕ್ರಮ ನಿಮಿತ್ತ ಚಿಕ್ಕಬಳ್ಳಾಪುರ ನಗರದ ಶಿಡ್ಲಘಟ್ಟ ವೃತ್ತ ಕರ್ತವ್ಯದಲ್ಲಿದ್ದಾಗ ದಾರಿ
ಡಿಸ್ಮಿಸ್ ಮಾಡಿಬಿಡೋದ?
He has never participated in disciplinary proceedings.
Aldri,
Not
we'll
replied to
assume.
the
He has not pursued, he has admitted everything. Is it ತಗೊಂಡು ಏನೋ ಒಂದು ಔಟ್ ಬರ್ಸ್ಟ್ ಆಗ್ತಿರ್ತದೆ, ಹುಣ್ಣಿಮೆ ಅಮಾವಾಸಿ ಎಂತದ ಒಂದ್ ಎರಡು ಶಬ್ದ ಜಾಸ್ತಿ ಬೀಳ್ತದೆ ಹೊರಗಡೆ ಬಾಯಿಯಿಂದ. ಡಿಸ್ಮಿಸ್.
He was suspended twice. He
ಅದು
never
how the
joined the
suspension does it add
My lord,
merits to your case?
he's.
This is D ಆಗಿದೆ. Is it a ground for dismissal? ಅಷ್ಟು ನೀಜರ್ಕ್ ರಿಯಾಕ್ಷನ್ ಅದೆಲ್ಲ ಅಷ್ಟು ಇಟ್ಕೊಂಡ್ಬಿಟ್ರೆ ನಂಗೆ ಈ ಮನೆಯಲ್ಲಿ ಸಹಿತ ಇಂಥ ಶಬ್ದ ಯಾವ್ಯಾವ ಮಾತಾಡಿ ಏನೋ ಒಂದು ಆಗ್ತದೆ, ಕನ್ಸಿಡರೇಷನ್ ಆಗ್ಬೇಕು. Notice. Learned DG is requested to accept notice for the respondent.
Complete documents are given.
ಆಯ್ತು ಆಯ್ತು. ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕಿ.
Copy ಸರಿ ಕೊಟ್ಟಿಲ್ಲ.
ಕೊಟ್ಟಿಲ್ಲ.
ಎಲ್ಲ ಇನ್ಕಂಪ್ಲೀಟ್ ಇದೆ ಅಂಡ್
ಕೊಡಿ.
ಹಿಂದೆ ಮುಂದೆ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಅದ್ ನಿಮ್ದು ಕೊಡಿ ಅವರಿಗೆ.
Yes.
ಅದ್ ನಿಮ್ದು ವಾಪಸ್
ಇದು ನನ್ನ ಕಾಪಿನೇ.
ನಿಮ್ ಕೊಟ್ಟು
Yes.
ನೀವ್ ಇಟ್ಕೊಳ್ಳಿ.
I will accept.
ತಗೊಳ್ಳಿ.
I'm sorry.
ಅದ್ ಮತ್ತೆ ವಾಪಸ್ ಕೊಡಬೇಡಿ.
I'm sorry.
ನಿಮ್ಮಿಂದ ಜೆರಾಕ್ಸ್ ಮಾಡ್ಕೋಬಾರ್ದು ಅವರು. See, thrice we have been observing you. This is third case. Don't do that. Don't do that. Next. Yes. Dispensed with. ಕೂತ್ಕೊಳ್ಳಿ, ನಾ ಕರಿತೀನಿ, ಕೂತ್ಕೊಳ್ಳಿ. ನೀವು ಅನ್ನಿಸ್ಲಿ ನಿಲ್ಲೋದು ಬೇಡ. ನಾಟ್ ಹೆಲ್ದಿ, ಗುಡ್, ನಾಟ್ ಗುಡ್ ಫಾರ್ ಹೆಲ್ತ್.
Lord, assistant petitioner is the assistant commissioner. The order is, what is questioned is the suspension order. On the ground that he has disposed of several cases without issue of notice is the ground, Lord, on which he has suspended. In all those cases, only Tahsildar was a party. So on the basis of the registered document, he directed entry of the names in the RTC. Now on the ground, my lord, 3 grounds, page 38. my lord. ಅದರಲ್ಲಿ ಆ ಟ್ಯಾಬ್ಯುಲರ್ ಕಾಲಮ್ ಅಲ್ಲಿ ಇದೆ, page 38 extracted. ನೋಟಿಸು ನೀಡದೆ ಆದೇಶಿಸಿರುವ ಪ್ರಕರಣಗಳು. In all these cases, Tahsildar was the respondent. He was never appearing before the Assistant Commissioner. ಒಂದೇ ವಿಚಾರಣೆಯಲ್ಲಿ ಪಕ್ಷಕಾರಿಗೆ ನೋಟಿಸ್ ಜಾರಿ ಮಾಡಿದ ಆದೇಶ 37. ಅಪೀಲು ಸ್ವೀಕೃತ ಇತ್ಯರ್ಥಪಡಿಸಿದ್ದು 6. ತಂತ್ರಾಂಶದಲ್ಲಿ ಅಳವಡಿಸಿದ್ದು ದಟ್ ಈಸ್ ನಥಿಂಗ್ ಟು ಡೂ ವಿತ್ ದಟ್. ಸರ್ಕಾರದ ಹಿತಾಸಕ್ತಿ ಇರುವ ಪ್ರಕರಣಗಳಲ್ಲಿ ತಹಸೀಲ್ದಾರಿಂದ ದಾಖಲೆ ಮಾಹಿತಿ ಪಡೆಯೋದು. ಇದ್ರ ಯಾವುದೇ ದೇರ್ ಇಸ್ ನೋ ಡೆಲಿಬರೇಟ್ ಆರ್ ವಿಚ್ ಹಿ ಹಸ್ ಡನ್.
30 ರಿಸರ್ವ್ ಮಾಡಿಕೊಂಡಿದ್ದ ಮುಂದೆ ಏನಾದ್ವು?
ಮುಂದೇನಿಲ್ಲ, ಓನ್ಲಿ ಒಂದು ಸಬ್ ಕೇಸಸ್ ಮಿಲಾಟ್ ದೇ ಫೈಲ್ಡ್ ರಿವಿಷನ್ ಅಷ್ಟೇ. ಆಲ್ ಪ್ರೈವೇಟ್ ಪಾರ್ಟೀಸ್ ಹ್ಯಾವ್ ನಾಟ್ ಚಾಲೆಂಜ್ ಎನಿ ಆಫ್ ದೀಸ್ ಥಿಂಗ್. Only in some of the cases, Deputy Commissioner has entertained revision petition and it is pending. There also there is no decision. If they wanted to suspend him, in revision petition, they should have decided in what way it is wrong. Thereafter, they could have initiated proceeding. Now, there is no decision, there is no examination of any of these matters, whether he has committed or wrong. Government issued a direction, dispose of 100 matters in 1 month. So,
ಎಲ್ಲಿದೆ?
ಇದರಲ್ಲಿದೆ page. I have pleaded in the petition itself. At page 58. ಅದು ಕೋರ್ಟ್ ಅಲ್ಲೂ ಆರ್ಡರ್ ಅಲ್ಲೂ ರೆಫರ್ ಮಾಡ್ತಾರೆ. This I have extracted. At 3.9.4, the document is also there. The applicant is bound by the direction of the Honorable Revenue Minister as well as circular issued by respondent at 15/9/23. State government is directed to dispose of the appeal as expeditiously as possible at any rate within a period of 3 months. The then Revenue Minister has directed all the State Commissioner to dispose of at least 100 cases in a month. In the event the applicant fails to dispose of the appeal, that may amount to misconduct having violated the direction issued under circular. That circular is also.
Perhaps your minister is under impression that all Tahsildar, the assistant commissioners are Nagprasanna. Only Nagprasanna can do 100 cases like this.
Not being a quasi-judicial authority, my lord.
Why did you direct the quasi-judicial authority to dispose of so many cases?
That doesn't mean, my lord.
Have you
that
ever
the
seen
court
even our Supreme Court saying it to a magistrate of 3rd class? How?
May I
100
submit-
ಕೇಸ್ ನಲ್ಲಿ ಮಾಡ್ಲೇಬೇಕು ನೀ ತಿಂಗಳಿಗೆ ಅಂತ ಅವ್ರಿಗೆ ಹೇಳಿದ್ರೆ
But
ಇನ್ನೇನ್ ಮಾಡ್ತಾರ ಅವ್ರು?
Judgment court.
ಅಲ್ಲಿ he should have jumped from the ಎಷ್ಟನೇ ಫ್ಲೋರ್ ನಲ್ಲಿ ವರ್ಕ್ ಮಾಡ್ತಿದ್ರು ಅವ್ರು, ಅಲ್ಲಿಂದ ಕೆಳಗಡೆ.
ಅಲ್ಲ, ಅದರಲ್ಲಿ
Instances
Supreme Court
where
has held,
notices were not
that Supreme Court has held that every error of law will not constitute a
That's right.
misconduct unless it is deliberate, done to favor some person. Now, there is no such allegation, my lord, and he is already transferred from that place to another place, Pandavpura, Mysore to Pandavpura.
ಅಲ್ಲಿಯೂ ಹಿಂಗ ಮಾಡ್ತಾನ ಏನು?
ಅಲ್ಲ, ಅಲ್ಲಿ ಈಗ ಎಚ್ಚೆತ್ಕೊಂಡಿದ್ದಾರೆ, ಈಗ ಇನ್ನೇನು ಡಿಲೇ ಮಾಡ್ಕೊಂಡು ಕೂತಿರ್ತಾರೆ ನೋಡಿ. ಈಗ ತಹಸೀಲ್ದಾರ್ ನೋಟಿಸ್ ಆರ್ಡರ್ ಮಾಡಿದ್ರೆ ತಹಸೀಲ್ದಾರ್ ಡಸಂಟ್ ಅಪಿಯರ್ ಬಿಫೋರ್. ಸೊ ಅದಕ್ಕೋಸ್ಕರ ಇಮಿಡಿಯೇಟ್ ಆಗಿ ಆನ್ ದ ಬೇಸ್ ಆಫ್ ದಿಸ್ ಕೋರ್ಟ್ ಆಲ್ಸೋ ಇಸ್ ಗಿವನ್ ಅನ್ ಒಪಿನಿಯನ್ ದಟ್ ವೆನ್ ದೇರ್ ಇಸ್ ಎ ರಿಜಿಸ್ಟರ್ಡ್ ಡಾಕ್ಯುಮೆಂಟ್ ಯು ಹ್ಯಾವ್ ಟು ಎಂಟರ್ ದ ಖಾತಾ
Supreme Court said that.
unless they are able to show that in a
ಈ
particular
ಎಲ್ಲಾ
case,
ಕೇಸ್ನಲ್ಲೂ ರಿಜಿಸ್ಟರ್ಡ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್,
ಎಲ್ಲ ರಿಜಿಸ್ಟರ್ಡ್ ಡಾಕ್ಯುಮೆಂಟ್,
ಆಲ್ ಕೇಸಸ್ ರಿಜಿಸ್ಟರ್ಡ್.
all cases. Only where government interest is involved, ಅವ್ರು ಹೇಳೋದು original grant itself is not there, so why did you transfer ಅಂತ 10 ಕೇಸಲ್ಲಿ ಹೇಳ್ತಾರೆ. In all other cases, registered document only, and some one in court order is there, one. ಒಂದೇ ವಿಚಾರಣೆಯಲ್ಲಿ
ಅಲ್ಲಿ
ಪಕ್ಷಕಾರಿಗೆ
ಎಂಟ್ರಿ ಮಾಡಿರ್ತಾ ನಿಮ್ಗೆ ಕೆಳಗಿನ ಕೋರ್ಟ್ ನಲ್ಲಿ, ಇದರಲ್ಲಿ ಟ್ರೈಬ್ಯುನಲ್ ಮುಂದೆ,
What?
ಟ್ರೈಬ್ಯುನಲ್ ಮುಂದೆ ಎಂಟ್ರಿ ಮಾಡ್ರಿ ಏನ್ರ ಇತ್ತಾ?
ಅಲ್ಲ, ಟ್ರಿಬ್ಯುನಲ್ ಅಲ್ಲಿ ಇರ್ಲಿಲ್ಲ ಅಲ್ಲ, ಇರ್ಲಿಲ್ಲ.
Learned AG issue notice. Learned AG is requested to accept notice for the first respondent. In short, point is involved, call this matter in the second week of January
Please, my lord.
2025. In the meanwhile, objections may be filed. And if not filed, right to file one stands extinguished. But Supreme Court said in 1992, an employee can be hauled up if there is lapse even in discharge of judicial functions.
No, but there's slight modification is there. Some of the judgment where they say every error of law
Is not a,
is not, then my lord, if that is were to be so, in many cases, High Court judgments are reversed in Supreme Court, and this entire hierarchy, as your lordship knows that famous saying, not that the
final or infallible.
Supreme Court also.
Correct. In fact, 50th year of Supreme Court. There is a book, 50 years of Supreme Court. Its name is Final but not Infallible. Very name, title of the
Correct,
book
correct.
itself. Yes.
My lords, I appear for the respondent number 1 in both these matters. I have moved the matters, my lords. My lords, there are two appeals.
Represent the applicant in the other matter, that are furnished a copy of the application file, so that I can file the objection.
Application kodi.
Please, my lords, I'll just tell your lordships, I'll give the copy, my lords. I've already given it. I'll give another copy. I'll just tell your lordship briefly what
Ad
the.
kodi ಆಮೇಲೆ ಮತ್ತೆ ನಾವು ಅವ್ರಿಗೆ ಕೊಡಿ ಮುಂದೆ will hear you. Next.
My lords, your lordships may give a date, my lords.
All right.
I'm only insisting because the respondent is 94 years old.
In the first week of January 2025,
My lords, may I
By
request an earlier
appellant
date, my
to-
lords?
the respondent to serve copy of the application and the counsel appearing for the appellant. Next.
My lords, may I make a humble request for an earlier date, my lords? Any
Earlier
date in
date,
December?
Nayanthara, may not be possible because we are in the mid of hearing 2013 appeals. Otherwise, I would have given. In fact, we have read the papers also. It's not very matter. Early hearing application allowed, post it in.
Serial number 6. ಇಲ್ಲ ಅದೇನೋ ಕೋರ್ಟ್ಗೆ ಕಳಿಸ್ತೀನಿ. ಮೇಲಡ್ ಸೀರಿಯಲ್ ನಂಬರ್ 6 ಮೇಲೆ
ಸರಿ.
Because of the employees, my lord, they moved the government, central government, seeking abolition of the contract labor. Because, my lord, they were all working on this cylinder, this thing, my lord, filling up cylinders and all that. Very same work being done by the regular employees. Then, my lord, there were two batch of employees. One batch of employees, my lord, since, my lord, that contractor Raja ran away, and after the contract, my lord, we were continued as the regular.
29/10 ಹಿಂದಿನ ಡೇಟ್ ಯಾವತ್ತದ ಆ 29/10 ಡೇಟ್ ಕೊಟ್ಟದ್ದು ಇವರು ವಾಟರ್ ಡೇಟ್ ಹಾಕಲ್ಲ ಬ್ಲಾಕ್ ಮಾಡಿ
ಶೇಖರ್ ಶೆಟ್ಟಿನ ಇದ್ರಾಗಿಲ್ಲ. Okay.
May I continue? Yes. Then, madam, in that other batch of employees, what happened, my lord?
ಇದು ಈ ಅವಧಾನದಲ್ಲಿ ನಡುವೆ ಅಧಿಕ ಪ್ರಸಂಗಿ ಅನ್ಕೊಂಡೊಂದು ಪಾತ್ರ ಬರ್ತದೆ. To distract the avadhani from concentrating on the subject of discussion, they will say something.
ಅದನ್ನ ಭಾರಿ ಜೋರಾಗಿ ಹೇಳ್ತಾ ಇದ್ದಾರೆ.
ಒಂದೊಂದ್ಸರಿ ನಮ್ ಸಿಸ್ಟಮ್ ಹಂಗ್ ಮಾಡ್ತದೆ.
ಅದು ಮಾಸ್ಟರ್ ಹಿರೇಣ್ಣ ಭಾರಿ ಜೋರಾಗಿ ಹೇಳ್ತಾ ಇದ್ದಾರೆ ಅದನ್ನ ಒಂದ್ಸಲ. Now, then what happened? After the contractor ran away, the employer continued our services. Once this contract labor was abolished, you were all terminated from service by the principal employer. Not disconnecting.
Read sale judgment. Sale says that way. Sale says 5 postulations have been laid down.
Exactly.
The second postulation, yes, second postulation is once that happens, section 10 notification.
How
10 notification is issued, the vinculum juris, even if it is there, it comes to an end.
Comes to an end.
And it become the employees of the contractor.
Yes, but then there was no contractor. My services were not terminated by the contractor because there was no contractor. My services came to be terminated by the principal employer. There, I took up a contention. This termination is bad in law. Who labor court held termination is bad. They have only granted some. Yes.
Who appointed you?
My appointment, even though is by the contractor.
Contract.
But change of contractor, my services continued throughout. Change of contractor.
To whom money was being, to whom money was paid?
Yes, contractor only.
But there is that. Then
That
it
is
says,
true.
then it says,
Yes.
who appointed?
Who pays?
Controls the work.
Yes.
Who pays the wages?
Yes, yes. Other time, in some
Three.
other case, we were all very
Yes.
same point was being agitated.
When he said that, we have
yes.
adopted also.
But in this case, after that contractor ran away, this employer only paid my wages.
When he ran, which date? he ran
92.
away? Huh?
92.
From
You were
there
continued
onwards?
till 2001.
From there onwards.
Yes.
Whether money is paid to your account directly?
No, by cash they were paying. By cash they were paying. We continue. That is not the dispute. Only 1,700 rupees was salary. Then, therefore, my lord, the tribunal held termination is bad. But, my lord, the question of reinstatement does not arise because, my lord, we were all aged. Therefore, my lord, they granted a meager compensation of 50,000 rupees.
This is not challenged by the other side?
No, they have not challenged. They have not challenged.
Which is that sale judgment?
Yes, ma'am.
Is it referred in this matter?
No, it's not referred. Because what happened?
Sale covers this issue.
Yes.
Sale
I am aware of that. That's Dharwad bill.
Correct.
Yes, yes.
You had argued that matter.
Yes, yes. You come in there. Because, my lord, my main grievance is, my lord, having health termination is bad while fixing the compensation. For in respect of the employees work for about.
Just compensation.
50,000 ರೂಪಾಯಿ ಕೊಟ್ಟಿದ್ದಾರೆ ಒಬ್ಬೊಬ್ಬರಿಗೆ. ಅದನ್ನು ಕೊಟ್ಟರು ಅಂಡರ್ ಪ್ರೊಟೆಸ್ಟ್ ಯು ಆರ್ ರಿಸೀವ್ಡ್ ಇಟ್ ಬಿಕಾಸ್ ವಿ ವರ್ ಲೆಫ್ಟ್ ವಿತ್ ನೋ ಅದರ್ ಬಿಕಾಸ್ ಗ್ರಾಜ್ಯುಟಿನೂ ಇಲ್ಲ ಇದ್ರೊಳಗೆ ಎಲ್ಲ ಸೇರಿ 50 ಅಂತ ಹೇಳ್ಬಿಟ್ರು. Lordship gas, not that particular
issue. Emergent notice. Only only to adjudge the rightfulness or otherwise of the quantum of compensation and the principles on which that has been done.
Yes.
First.
And if I am not,
we make it clear that the challenge is confined only to that.
Not in the mean,
quantum of compensation. Confined only to quantum of compensation. It's confined only to quantum of compensation.
In the meantime, the trial court records may be called. If it is, otherwise one should not get adjourned for that ground. CGIT Bangalore.
I appear for petitioner, my lord.
Yes, Mr. Shetler. But Heli.
Your lordship may be pleased to say this petitioner is the owner of the agricultural land I mentioned in the para 2 of the writ petition. This
ನಿಮ್ಗೆ ಇನ್ನೊಂದು ಹೇಳೋದಿದೆ ನಾವು. ಒಂದು ಪರ್ಮನೆಂಟ್ ಸ್ಟೇ ಅಗೇನೆಸ್ಟ್ ಏಜಿಂಗ್ ಇದೆ ನಿಮಗೆ. ಯಾರು ಕೊಟ್ರು ಆ ಸ್ಟೇನ ಅಂತ?
ಯಾರು?
You have obtained permanent stay against aging.
I could not follow your lordship.
You
sorry.
continue to be young eternally by order of the court.
Who granted stay for your age?
ಹಾಗೆ ಇದೆ.
Not by the stay order granted by the God. ನಾನು ಅದೇ ಹಂಗ್ ನೋಡ್ತಾ ಇದ್ದೆ ನಾನು. ಹಿಂಗಿದ್ದಾರೆ ಸುಮಾರು ದಿವಸ ಆಯ್ತು ನೋಡಿ.
ಅದು ನಿಮ್ಗೂ ಅಪ್ಲೈ ಆಗತ್ತೆ. ಏನ್ ಶೆಟ್ರೆ ಹೇಳಿ.
It is a kumki right, my lord. It is undisputed fact. We have got the Patta lands. It is adjacent to that according to the Madras Forest Act. This is a South Canara. Madras Forest Act, up to the depth of 100 square feet.
Adjoining your land.
Adjoining all the through. And it is undisputed, this land is adjacent to my land. It is undisputed, this measures 2 acres. And they only unfortunate thing is they do not know what is the kumki right. That's why never considered at all. One stage in the
ಗೊತ್ತಿಲ್ಲ ಕುಮ್ಕಿ ರೈಟ್ಸ್ ಎಕ್ಸೆಪ್ಟ್ ಒನ್ ಬುಕ್.
ಅದಕ್ಕೆ
ಕುಮ್ಕಿ ಲ್ಯಾಂಡ್ ಅನ್ಕೊಂಡು ಒಂದು ಪುಟ್ಟ ಪುಸ್ತಕ ಇತ್ತು, ಒಂದು 80
ಇಲ್ಲ ನಾನು ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಡಿಸಿಷನ್ ಕೊಟ್ಟಿದ್ದೆ ಅದಕ್ಕೆ.
ಅದೇ ಅದನ್ನ ಕೋಟ್ ಮಾಡಿ ಬಂದಿದ್ರು.
ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಡಿಸಿಷನ್ ಇದೆ, ಅದ್ರಂಗೆ ಕ್ಲೀನ್ ಆಗಿ ವಾಟ್ ಇಸ್ ಕುಮ್ಕಿ ರೈಟ್ ಅನ್ನೋಡಿ ಹೇಳಿ.
ಓದ್ಕೊಳ್ಳಿಕ್ಕೆ ಇವು ಹಸುಗಳನ್ನು ಬಿಟ್ಕೊಳ್ಳಿಕ್ಕೆ ನಂತರ ಕ್ರಾಶಿಂಗ್ ಯಾರ್ಡ್ ಎಂಥದ್ದು ಮಾಡ್ಕೊಳ್ಳಿ ಕಾಲ್ ಅಂಡ್ ರೈಟ್ಸ್ ಅನ್ನು ಬಂದಿತ್ತು ಅಂತ.
I have produced the Supreme Court decision itself. The first decision is the Supreme Court. Your Lordship, take para to your Lordship get all the.
ಆಯ್ತು ಇರಿ ಒಂದ್ ನಿಮಿಷ ಇರಿ. ಆಯ್ತು, we have understood. ನೋಡಿ, ಸ್ಮಾಲ್ ಬುಕ್ ಇದೆ, ಲಾ ರಿಲೇಟಿಂಗ್ ಟು ಕುಮ್ಕಿ ಲ್ಯಾಂಡ್ಸ್ ಅಂತ. ಮೋಸ್ಟ್ಲಿ ಶಂಕರ್ ಭಟ್ರು ಬರ್ದಿದ್ರು ಅಂತ ಅನ್ಕೋತೀನಿ. ನಿಮ್ಮ ಫ್ರೆಂಡ್ ಇರ್ಬೇಕು ಅವ್ರು, ಎಂ ವಿ ಶಂಕರ್ ಭಟ್ರು. ಅದರಲ್ಲೆಲ್ಲ ಡಿಸೈಡ್ ಇದು ಆಗಿದೆ, ಅನೇಕ ರೂಲಿಂಗ್ಸ್ ಎಲ್ಲ ಕೊಟ್ಟಾರೆ. ಅದು ಒಂದು ಸ್ವಲ್ಪ ಸ್ಪೆಷಲ್. ಹೆಂಗೆ ಕುಮ್ಕಿ ನಿಮ್ಮ ಕುಮ್ಕಿ ಅಲ್ಲಿ ಕೂರ್ಗಿಗೆ ಜಾಮಾ ಲ್ಯಾಂಡ್ ಬರುತ್ತಲ್ಲ, ಆ ರೀತಿ ಒಂದ್ ಸ್ವಲ್ಪ ಇದೆ. ಅದು ಒಂದು ನೋಡ್ಕೊಂಡು ಮಾಡ್ಬೇಕಾಗ್ತದೆ. ಅದೆಲ್ಲ ಕನ್ಸಿಡರ್ ಮಾಡಿಲ್ಲ ಅವರು.
ಮಂಗಳೂರು ಸೈಡ್
ಇದೆ ನಮ್ಮ ಜಸ್ಟಿಸ್ ಎಸ್ ವೆಂಕಟರಾಮನವ್ರದ್ದು ಒಂದು ಜಡ್ಮೆಂಟ್ ಇದೆ. ಒಂದು ಜಡ್ಮೆಂಟ್ issue notice, examine ಮಾಡನಂತೆ. Issue emergent notice, interim order as prayed for till next date of hearing.
Objection is, my lordship, rejected.
Objection is rejected. ಅಲ್ಲ, ಅವರಿಗೆ ಇಟ್ಸ್ ಎ ಕ್ರಿಮಿನಲ್ ಕೇಸ್ ಆಲ್ಸೋ. ಯಾಕಂದ್ರೆ imprisonment
from Mangalore she has to come here. In spite of your lordship directed to grant the exemption, the cost of rupees 2,000 levied. I have paid it. I have got a receipt here.
Not talking. ಎಲ್ಲರೂ ಮಂಗಳೂರಷ್ಟು ಬೆಂಗಳೂರಾಗಿ ಬರ್ಬೇಕು. ಬಿಡಿ.
Matter relates to audit officer's post, direct recruitment to Hyderabad Karnataka cadre. They're part of the Hyderabad Karnataka cadre. Their prayer notes was seeking for promotion in the residual parent cadre, stating that in the overall seniority, our juniors who are in residual parent cadre are getting accelerated promotion. What happens if there are 2 cadres for the purpose of seniority, promotion, everything?
371J orders.
It's a separate unit. There is it is also produced before my lords. And court has directed us to issue an
incidentally ಆ ಕ್ವೆಶ್ಚನ್ ನಾವು ಕನ್ಸಿಡರ್ ಮಾಡ್ತಾ ಇದ್ದೇವೆ ಇದರಲ್ಲಿ.
ಇಲ್ಲ, ಅದರಲ್ಲಿ ಅದು ಕನ್ಸಿಡರೇಷನ್ ಬರಲ್ಲ. But court kindly see the operative portion.
No, we agree with you. Please read that. Issue emergent notice and interim order as prayed for till next date of hearing.
Grateful.
ಶಂಕರ್ ಭಟ್ರು ಒಂದು ಲಾ ರಿಲೇಟಿಂಗ್ ಟು ಟೆನೆನ್ಸಿ ಮೇಲೆ ಎಷ್ಟು ಚೆನ್ನಾಗಿ ಬರ್ದಾರೆ. ಟೆನೆಂಟ್ಸ್ 1961 ಆಕ್ಟ್, ಕರ್ನಾಟಕ ರೆಂಟ್ ಕಂಟ್ರೋಲ್ ಆಕ್ಟ್ ಮೇಲೆ.
ಈಗೆಲ್ಲ ಮುಗಿದೋಯ್ತಲ್ಲ ರೆಂಟ್ ಕಂಟ್ರೋಲ್ ಆಕ್ಟ್.
ಹಳೆಯ ಸಂತಾನ ಮೇಲೆ ಬರ್ತಾರೆ.
ಹಳೆಯ ಸಂತಾನ ಇನ್ನೊಂದು ಹಳೆಯದು ಇನ್ನೊಂದಿದೆ.
Okay.
ಹಳೆಯ ಪುಸ್ತಕ ಅಲ್ಲಿ ಫಾದರ್ ಹಳೆಯ ಸಂತಾನ he was the expert on that. ಎಲ್ಲರಿಗೂ ಪಾಠ ಹೇಳೋರು.
ಹೌದು.
ಫಿಕ್ಸ್ ಮಾಡ್ಲಿಕ್ಕೆ ಆಯ್ತು.
ನಮ್ದು ಎಲ್ಲ ಲೈಬ್ರರಿಲಿ ಕುತ್ಕೊಳ್ಳಿಕ್ಕೆ ಕಳಿಸ್ತೀರ ನಿಮ್ ತಂದೆ. ಎದ್ದು ಹೋದ್ರೆ ಹಿಂಗೆ ಎಷ್ಟು ಸರಿ ಹೋಗ್ತೀಯ ನೀನು, ಸುಮ್ಮನೆ ಕುತ್ಕೋಬೇಕು ಅಷ್ಟ ಅವೆಲ್ಲ ಪ್ರಾತಸ್ಮರಣೀಯದವರಿಂದಾಗಿ ಏನೋ ಒಂದು 4 ಅಕ್ಷರ ಕಲ್ತ್ವಿ ನಾವು. He was my guru. The father was my guru. Yes, sir.
Serial number 10. Other
10.
side. For final. ಮಾಡಿದ್ದಾರೆ.
ಏನು ಟೈಮ್ ಕೊಡಲ್ಲ ನಾವು.
ಅಲ್ಲ
ಎಲ್ಲ ಓದ್ಕೊಂಬಂದ್ಬಿಟ್ಟಿವಿ.
ನಾನ್ ರೆಡಿ, ಅವರು ಗೊತ್ತಿಲ್ಲ. ಅವ್ರು
ಬಂದ್ರೆ ಆರ್ಗ್ಯೂ ಮಾಡಿ, ಅವ್ರು ಬಂದ್ರೆ ನೀವು ಅವ್ರು ಕೇಳ್ತೇವೆ ನಾವು. ನಾವು ಟೈಮ್ ಕೊಡಲ್ಲ. ಹಾಗೆ ಮತ್ತೆ ಓದಂಗಿರಲ್ಲ ನಮ್ಗಿದು.
An agreement of lease was
Yes.
entered in, sorry.
Yes, sir.
Agreement of lease was entered into between the petitioner and Mullard, the respondent. If my lord sees, Canara Bank, Chitrapur Mutt was the owner of the property. We entered into an agreement, paid my lord the entire premium in advance. They were to my lord execute a lease deed and register it. They did not register.
ಫೋನ್ ಮಾಡಿ ಅನ್ಕೊಂಡು
ಮಾಡಿದ್ದಾರೆ. ಏನೋ ಮೂವ್ ಮಾಡಿದ್ರಂತೆ, ತಮ್ಮ ಡೇಟ್ ಫಿಕ್ಸ್ ಮಾಡ್ಬೇಕು ಅಂತ ಏನೋ ಕೇಳಿದ್ರಂತೆ, ಗೊತ್ತಿಲ್ಲ. ಮೈ ಇನ್ಸ್ಟ್ರಕ್ಟಿಂಗ್ ಕೌನ್ಸಿಲ್ ಟೆಲ್ಸ್ ಮಿ, ಮೈ ಕಲೀಗ್ ಏನೋ ತಮ್ಮನ್ ಕೇಳಿದ್ರಂತೆ, ಒಂದು ಡೇಟ್ ಫಿಕ್ಸ್ ಮಾಡಿದ್ರೆ ನಾವು ಬರ್ತೀವಿ ಸೀನಿಯರು ಹಾಗೆ ಹೀಗೆ ಅಂತಾರಂತೆ, ಗೊತ್ತಿಲ್ಲ ನನಗೆ.
ಒಂದಾದ್ರೆ ಡೇಟ್ ಹೇಳಿ,
ತಾವು ಯಾವತ್ತು ಹೇಳಿದ್ರೆ ಅವತ್ತು ಬರ್ತೀನಿ. ನಾನು
ಮೂವ್ ಮಾಡಿಕೊಂಡು ಬರ್ಲಿದ್ರೆ ನಾವೇನ್ ಮಾಡಿ, ಎಷ್ಟು ಸರಿ ನಾವು ಓದ್ಬೇಕು.
ಕರೆಕ್ಟ್.
ಆಮೇಲೆ ಅಷ್ಟೇ ಚಂದ ಇರಂಗಿಲ್ಲ ಇದು.
ಏನಿಲ್ಲ ಇದ್ರೊಳಗೆ ಶಾರ್ಟ್ ಕ್ವೆಶ್ಚನ್,
ಶಾರ್ಟ್
ಅಷ್ಟೇ.
ಬುಕ್ ಅಷ್ಟೇ ಮತ್ ಓದೋದು ಅದೇ
I'll try and make a note and then give you a lordship's money.
All this matter in the ಯಾವಾಗ ಹೇಳಿ, ನೀವು ಹೇಳಿ ಡೇಟಿಗೆ ಹಾಕು, ವಿಚ್ ಎವರ್ ಡೇಟ್ ಯು ವಾಂಟ್. ಅವತ್ತು ಅವ್ರ ಬ್ಯಾಂಕು ಬರಲೇಬೇಕು, ಅವ್ರನ್ನ ಕರ್ಕೊಂಡು ಬರ್ಬೇಕು ನೀವು. ಎರಡೂ ಕಂಡೀಷನ್. ಅವ್ರನ್ನ ಕರ್ಕೊಂಡು ಅವರೇ ಮೂವ್ ಮಾಡಿದ್ನಿ.
ಆರ್ನಲ್ಲಿ ಇರ್ಲಿ,
ಯಾವ್ದು
ಯಾವತ್ತಾದ್ರೂ 3ನೇ ತಾರೀಕು ಆಗ್ಬೋದಾ, ಡಿಸೆಂಬರ್, ಅಥವಾ ಇನ್ನು ಬೇಗನೆ ಬೇಕು ಅಂತ?
ಇಲ್ಲ, ಇದು ಅಲ್ಲಿ 3ನೇ ತಾರೀಕಿಗೂ ಆಗಲ್ಲ ನಮ್ಗೆ. ಇನ್ನೊಂದು ಸ್ವಲ್ಪ
ಇನ್ನು ಆ ಕಡೆನಾ?
ಸ್ವಲ್ಪ
ಆಯ್ತು. ಐ ನೋ ವಿಲ್ ಬಿ ಸೋ ಬಿಸಿ.
2017 ವೆರಿ ಶಾರ್ಟ್ ಪಾಯಿಂಟ್ ಇದೆ.
ಹೌದೌದು. ಒಂದು
17 ಹಾಕೋಣ.
17
ಡಿಸೆಂಬರ್ 17
ಡಿಸೆಂಬರ್ ಮೇಲೆ ಆಗ್ಬೋದು. ಆಯ್ತು.
ಅಲ್ಲ ನಿಮ್ಗೆ ಬೇರೆ
ಏನ್ ತೊಂದರೆ ಇಲ್ಲ. ಐ ವಿಲ್ ಬಿ ಹಿಯರ್. ಐ ಆಮ್ ಆಲ್ವೇಸ್ ಇನ್ ದ ಕೋರ್ಟ್.
ಅಲ್ಲ ಅವ್ರು ಬರ್ಬೇಕಲ್ಲ, ಅವ್ರು ಕರ್ಕೊಂಬರಿ.
I'll try and make a list of dates and synopsis.
Matter lies in a very narrow compass.
ಮಾಡ್ಬಿಟ್ಟು evidence ಅಲ್ಲಿ ಏನಿದೆ ಅಂತ ಹೇಳಿ ಬರೀ ಒಂದು 4-5 ಪೇಜ್ ಮಾಡ್ಕೊಟ್ಬಿಡ್ತೀನಿ.
Yes.
Respondent number
one. This is a case where the second bidder has been awarded the property without, when the first bidder failed. First bidder.
ನೋಡಿದ್ರಾ?
We have checked up with Supreme Court library also not available. Supreme Court library also not available.
ನಮ್ಮ ಮಹೇಶ್ವರಿ ಸಾಹೇಬ್ರು ಇಸ್ಕೊಂಡಿದ್ರು ಅದನ್ನ. somehow I also forgot to get it back.
No, even checked with even Supreme Court library also. It's not available.
ಅವು ಯಾವಾಗೂ ಹಂಗೆ ಪುಸ್ತಕ ವನಿತಾ ವಿತ್ತಂ
ಪರಹಸ್ತಂ ಗತಂಗತಃ ಪುನರಾಯತಂ ತೀರ್ಣಂ ಪ್ರಶ್ನಾಚ ಕಂಠಸಃ.
Then our library also it's not there, my lord.
The question is where the highest bidder withdraws.
Yes.
Whether second in the rank can take the property is the issue. Our impression is unless law provides.
No, my lord, here
what the law provides.
My lord, here what has happened is.
ಪೂರ ಕೇಳ್ಕೊಳ್ಳಿ, ಅಷ್ಟೇ ಇದೆ, ಓದ್ಕೊಂಬಂದೇವು ನಾವು, ಅಷ್ಟೇ ಇದೆ. ಹೈಯೆಸ್ಟ್ ಬಿಡ್ಡರ್ ಅದನ್ನ ಫಾರ್ಫಿಟ್ ಮಾಡಿದಾರನ ಅವ್ರ ಅಮೌಂಟ್ ಅನ್ನ?
ಇಲ್ಲ, ಅವರು ಅಮೌಂಟ್ ವಿತ್ಡ್ರಾ ಮಾಡ್ಕೊಂಡ್ರು. They got back the money from this court. Page 47 is the order.
Lord, here what has happened is,
Then
the
they
secured
wrote
creditor
re-auction.
has called the second bidder, requested him to match with the price of the first bidder. But that is for 12.88 crores. Whereas they have confirmed the sale for 11.3 crores, my lord. Despite telling him you have to match with the first bidder, they have not done it. Sale certificate is issued for 11.3.
My lords, I appear for respondent 1 and 2. My lords, there's been a bereavement in the family of the arguing counsel. Means, my lords, immediate family, his grandmother. Objections are ready, my lords. We will file it within 2 weeks' time. my lords.
2 weeks, sir. Already 2 months was in gap.
ಅಲ್ಲ ಮತ್ತೆ 10ನೇ ದಿವಸ ಇದೆಲ್ಲ 13ನೇ ದಿವಸ ಎಲ್ಲ ಆಗ್ಬೇಕು.
Yes, yesterday they passed, my lord.
ಬೆರಿಮೆಂಟ್ ಆಗಿದೆ ಅಲ್ಲಿ. Call off.
A date may be fixed, my lord.
A date may
Call
be
off for
fixed.
3 weeks.
Grateful, my lord.
3 weeks, sir. On the ground of bereavement in the family of arguing counsel appearing for the respondent. Date ಕೊಡಿ. Entry matter ಇದೆ. Entry matter to continue. Calling the third week of January 2020. Yes, next.
Grateful.
My lord, a date may be fixed.
ಅದು ಜನರು ಕೊಟ್ಟಿದ್ದೇವೆ. ನೆಕ್ಸ್ಟ್ ಬೆಂಚ್ಗೆ ನಾವೇನ್ ಕೊಡು. ಅವಾಗ ಏನೇನಾಗ್ತದೆ ಅಂತ ಯಾರಿಗೂ ಗೊತ್ತು.
Grateful.
ನಿಮ್ಗೆ ಎಂಟ್ರಿ ಮಾಡಿದೆ ಅಪ್ಪ. Yes.
Lokaयुಕ್ತ has preferred the.
ಏನಿದು ಮ್ಯಾಟರ್? ಕೋರ್ಟ್ ಮೂವ್ ಮಾಡಿದ್ದಾರೆ, ಬಂದಿಲ್ಲ.
2 orders were passed by the government. So, my lord, one was set aside by the tribunal. My lord. That was challenged. That is challenged by the Lokaयुಕ್ta.
Where is our Dharwad bench judgment? Dharwad bench judgment tell you.
My lord, in page 158 of the writ petition.
150?
158, my lord. There are 16, my lord. If my lords may kindly see 159. First penalty order was passed on 19/12/2019. 159.
Yes.
Charges were bribe, prevention.
Serial number 13. Kindly pass over, my lord.
Pass over. Pass over. Dharwad judgment number bekadna. Where we discussed we have followed that, we have interpreted the Captain Justice Satish Sharma's judgment na.
Yes, my lord.
ಅದು ತೊಂಬರ್ಬೇಕು.
Yes.
ಅಷ್ಟೇ ಅದು. ಒನ್ ಆಫ್ ದಿ 5 postulates ನ ಬಿದ್ರೆ ಅಷ್ಟೇ ನಿಮ್ಗೆ ಲೋಕಸ್, ಅದರ್ವೈಸ್ ಲೋಕಸ್ಸೇ ಇಲ್ಲ. ಪಾಸ್ ಓವರ್ ಬಿಟ್ಟು ತೊಂಬರಿ ಕೊಡಿ. ನೆಕ್ಸ್ಟ್.
I may be permitted to appear for Muzaffar.
Yes, brother Muzaffar. ಏನಿದೆ?
Lord, the petitioner and the third respondents are professors. Lord, the third respondent files an application before the Karnataka Administrative Tribunal challenging my posting as in-charge principal. Lord, her case is that she is senior to me and she should be given the post of in-charge principal. Lord, I filed my objection. My contention was she was posted, she worked as principal, and she has given up the post, saying that she is unable to handle that. Thereafter, it was entrusted to me. Ide adralli page number 179, your lordship.
179.
Dated 21/2023.
ಮಾನಸಿಕ ಹಿಂಸೆಯಿಂದ ಹುದ್ದೆಯನ್ನು ಬಿಟ್ಟುಕೊಡುವ ಬಗ್ಗೆ.
ಮೇಲ್ಕಂಡ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಸರ್ಕಾರಿ ಪ್ರಥಮ ದರ್ಜೆ ಕಾಲೇಜಿನಲ್ಲಿ 2 ಅವಧಿಗೆ ಪ್ರಿನ್ಸಿಪಾಲ್ರ ಕರ್ತವ್ಯ ಪ್ರಭಾರವನ್ನು ಅತ್ಯಂತ ಸಮರ್ಥವಾಗಿ ನಿರ್ವಹಿಸಿದ್ದ ನನಗೆ ಇತ್ತೀಚೆಗೆ ನನ್ನ ಸಹೋದ್ಯೋಗಿಗಳು ಕೆಲವರ ಆಡಳಿತಾತ್ಮಕ ಅಸಹಕಾರ ಧೋರಣೆಯನ್ನು ಸರಿಪಡಿಸುವ ಸದುದ್ದೇಶದಲ್ಲಿ.
Who appears for this private response? You appear. How this aspect is treated by the tribunal?
Lord, the tribe, in between what transpires, my lord, she was transferred to Hebbal College on 3/6/2023. Now, 2 dates may be important for us. 3/6/2023.
ಇದೇನಿದು?
ಇವರು ಇಲ್ಲಿಂದ ಯಲಹಂಕ ಕಾಲೇಜಿಂದ ಹೆಬ್ಬಾಳಕ್ಕೆ ಹೋಗ್ತಾರೆ ಆಫ್ಟರ್ ಗಿವಿಂಗ್ ಅಪ್ ದಿ ಪೋಸ್ಟ್.
From Yelahanka to
ಹೆಬ್ಬಾಳ್. Then I was posted at principal.
private respondent. ಏನ್ ನಂಬರ್ ಅದು?
Respondent number 3.
From
Yelahanka college to First Grade College to Hebbal. First Grade College Hebbal. Then my lord, I was posted as in charge principal on 10/7/2023.
3/6 ನಿಂದ 10/7 ವರೆಗೆ ಯಾರು ಇರಲಿಲ್ಲ.
ಯಾರು ಇರಲಿಲ್ಲ. ಅಲ್ಲಿ ಇನ್ನೊಬ್ರು ಇದ್ರು ಮಲ್ಲಿಕಾರ್ಜುನ್ ಅಂತ, ಅವ್ರು ರಿಟೈರ್ ಆಗ್ತಾರೆ. He was there.
He was holding
ಮಲ್ಲಿಕಾರ್ಜುನ್ ಅಂತ ಇದ್ದಾರೆ.
ಮತ್ತೊಂದು ಹೇಳ್ಬೇಕು. 10/7/2023 ನೀವು ಬಂದ್ರ ಅಲ್ಲಿಗೆ?
ಅಲ್ಲಿಗೆ ಬಂದು.
ನಿಮ್ಗೆ ಇದು ಇದೆಯಾ ಟು ಹೋಲ್ಡ್ ದಟ್ ಪೋಸ್ಟ್ ಕ್ವಾಲಿಫಿಕೇಶನ್?
Qualification ಇದೆ. Both are in charge post. It is not a full time post. Regular principal ಇಲ್ಲ. Both of us are in charge post.
OOD principals, all the principals, director of collegiate education are OOD principals.
Okay. ಗೆ.
Yes, my lord. 10/7 I was posted.
ಹಾ.
ಇವರು ಹೆಬ್ಬಾಳಿಂದ ಬಂದ ಮೇಲೆ then she makes an representation.
Representation dated?
But second.
ನಮ್ಗೆ ಆ ಪೋಸ್ಟ್ ಕೊಡಿ ಅಂತ.
ಹೌದು, ನನ್ಗೆ ಕೊಡಿ ಅಂತ ಕೊಡ್ತಾರೆ.
ಟ್ರೈಬ್ಯುನಲ್ ಏನ್ ಹೇಳ್ತದೆ?
ಟ್ರೈಬ್ಯುನಲ್ ಹೇಳ್ತಿರೋದು ಅವ್ರನ್ನ
ಕೊಡಬೇಕು,
ಅವರಿಗೆ ಕೊಡಬೇಕು, ಬಿಕಾಸ್ ಶಿ ಇಸ್ ಇನ್ ಚಾರ್ಜ್, ಸಿ ಸೀನಿಯರ್. ಮೈ ಕಂಟೆನ್ಷನ್ ವಾಸ್ ಶಿ ಹ್ಯಾಡ್ ಗಿವನ್ ಅಪ್ ದ ಪೋಸ್ಟ್ ಅಂಟಿಲ್ ದಿ ನೆಕ್ಸ್ಟ್
ಟೇಕ್ ಔಟ್ 91 ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಕೊಡಿ. ಅಲ್ಲಿ ಇದಕ್ಕೆ ILR 2006 ಕರ್ನಾಟಕ ಇದನ್ನು ಬಸವರಾಜ್ ಧೋತ್ರದ ಕೊಡಿ, ಅದರಲ್ಲಿ ರೆಫರ್ ಆಗಿದೆ. ರಾಮಾಜೀಸರು ಹೇಳಿದಾರೆ ಇನ್ಚಾರ್ಜ್ ಇಂಡಿಪೆಂಡೆಂಟ್ ಚಾರ್ಜ್ ಇದ್ದಲ್ಲಿ ಸೀನಿಯಾರಿಟಿ ಈಸ್ ನೋ ಫ್ಯಾಕ್ಟರ್ ಅಂತ ಕೊಡಿ. BN ಧೋತ್ರದ್ ವರ್ಸಸ್ ಕರ್ನಾಟಕ ಲ್ಯಾಂಡ್ ಆರ್ಮಿ ಕಾರ್ಪೊರೇಷನ್.
Before going to that, annexure R3 and bad, that is my lord, I have taken a defense saying that it's by pressure. The pressure obtained my lord this letter. Simultaneous my lord, the next document R4, he has also given representation saying that I am not interested in as a principal. Avaru kottadana bad illi anta.
ಅವ್ರದ್ದು ಲೆಟರ್ ಯಾವಾಗಿಂದ?
that is 20 January
annexure
2023.
R4 ಇದು annexure R3.
So far as letter is concerned, both you stand at the same footing.
But ಏನಾಯ್ತು ಅಂತಂದ್ರೆ, I was working, when she has given the representation, I was holding the post. But that time when I gave the letter in my turn, I said, I am not interested. My lord, what Supreme Court says is, once it is given up, they will have to climb only in the next cycle. Referring to, it is not akin to the similar rule.
ಅದು ಇನ್ಚಾರ್ಜ್ ಅಲ್ಲ,
ಇನ್ಚಾರ್ಜ್ ಆಗಿರೋದ್ರಿಂದ
ರೆಗ್ಯುಲರ್ ಪೋಸ್ಟ್ ಪೋಸ್ಟಿಗೆ ಪ್ರಮೋಷನ್ಗೆ
ಅಷ್ಟೇ.
ಸುಪ್ರೀಂ ಕೋರ್ಟ್.
My lord,
Yes, my lord, that's
the notification,
Yeah.
the government orders of the state is whoever, my lord, the senior in the hierarchy of my lord, the seniority list, he should hold the post as a in-charge principal. That's one aspect. I am a qualified PhD holder.
ಒಂದು ನಿಮಿಷ ನೀವು ಹೇಳಿ ಒಂದು ಸೆಂಟೆನ್ಸ್ ಹೇಳಿ ಸುಮ್ಮನಿರು, ನಾವು ಪ್ರೊಸೆಸ್ ಮಾಡ್ಬೇಕಲ್ಲ. ನೀವು ಸರಿನೋ ತಪ್ಪೋ ಏನು ಅನ್ಕೊಂಡಿಂದ ಲೈಟ್ ಸ್ಕ್ಯಾನಿಂಗ್
I am the senior. Then
ಗೌರ್ಮೆಂಟ್ ಆರ್ಡರ್ ಯಾವಾಗಿಂದು?
government order, my lord.
That post judge after the judgment of Justice Ramajais or only
latest 10/10/23.
10/10/23.
That's
Because that was not there. In 1991 Supreme Court, which Dhotrad case refers to, Justice Najir Sahib referred to that 1991 Supreme Court and said, in charge arrangement and independent charge arrangement nalli seniority is not a factor ಅಂತ Supreme Court hold ಮಾಡಿತ್ತು. But that was, such an instrument was not there. ಅಲ್ಲಿ ಹಂಗಿದ್ದಾಗ Seniority, ನಿಮ್ದು ಲೆಟರ್ ಇದೆ, ಅವ್ರದ್ದು ಲೆಟರ್ ಇದೆ. ಹಾಗಾಗಿ ಲೆಟರ್ ಕಿಲ್ಸ್ ಲೆಟರ್.
Letter
So we will keep it aside. Independently argue ಮಾಡ್ಬೇಕು. What is there?
ಇದರಲ್ಲಿ my submission is, my lord, definitely she can claim only when the next cycle becomes open. Because she has given up the post, I am holding the post. She cannot be transferred to a post where I am holding as principal. If it is vacant, yes, the government is right. My lord, the circular which he is referring, kindly have a look at page 118.
ಇಲ್ಲಪ್ಪ ಅಂದ್ರೆ ಏನಾಗ್ತದೆ, ನಾಳೆ ಜೂನಿಯರ್ ಮೋಸ್ಟ್ becomes the principal, all seniors have to obey him.
ಹೌದು.
That lot of heartburn in any service sector.
But ಇಲ್ಲಿ ಅವರು ಗಿವನ್ ಅಪ್
ಬಿಡಿ, ಗಿವನ್ ಅಪ್ ಆರ್ಗ್ಯುಮೆಂಟ್ ಅದು ಇಬ್ರು ಗಿವನ್ ಅಪ್ ಮಾಡಿ ನೀವು.
ಅಲ್ಲ, ನನಗೆ ಗಿವನ್ ಅಪ್ ಮಾಡಿರೋದು ಅವಾಗ ಅದು ವೇಕೆಂಟ್ ಇದ್ದಾಗ ನಾನು ಗಿವನ್ ಅಪ್ ಮಾಡಿರೋದು. ಅವರು ಆಕ್ಯುಪೈ ಮಾಡಿ ಗಿವನ್ ಅಪ್ ಮಾಡೋಗಿದ್ದಾರೆ.
ಅಲ್ಲ, ಹೌ ಕ್ಯಾನ್ ಯು ಎಕ್ಸ್ಪೆಕ್ಟ್ ಎ ಸೀನಿಯರ್ ಟು ವರ್ಕ್ ಅಂಡರ್ ಯುವರ್ ಈಜಿಸ್? ಸೀನಿಯರ್ ಶುಡ್ ವರ್ಕ್ ಅಂಡರ್ ಯು. ಸೊ ಸಿಂಪಲ್. ಒಬ್ಬ ಸೀನಿಯರ್ ಇದ್ದವ್ರನ್ನ ಬಿಟ್ಟು ಜೂನಿಯರಿಗೆ ಒಂದು ಪ್ರಿಫರೆನ್ಸ್ ಕೊಟ್ರೆ ಆಮೇಲೆ ಏನಾಗ್ತದೆ, ಯು ವಿಲ್ ಬಿ ರೈಟಿಂಗ್ CR, ACR, ಇದೆಲ್ಲ ಆಸ್ಪೆಕ್ಟ್ ಬರ್ತದೆ. ಮಾಡೋಂತರಿ ಅವ್ನಿಗೆ ಈ ಪೋಸ್ಟಿಗೆ ಬರ್ದಂಗೆ ಇನ್ನೊಂದ್ಸಾರಿ ಅನ್ಕೊಂಡು ಅಲ್ಲಿ ಒಂದೇನೋ ಕೆಡಿಸಿ ಕುತ್ಕೊಂಡ್ಬಿಟ್ರೆ many aspects. Seniority is a norm.
ಇಬ್ರು ಅಪಾಯಿಂಟೆಡ್ ಆನ್ ದಿ ಸೇಮ್ ಡೇ. Because only thing is
ಯಾವತ್ತು ಅಪಾಯಿಂಟ್ ಅಲ್ಲ, ಸೆಲೆಕ್ಟ್ ಲಿಸ್ಟ್ ನಲ್ಲಿ ಎಲ್ಲಿ ನೀವು ಅನ್ನೋದು
there is no dispute.
Not when
PhD holder, my lord,
if you are appointed at the mid.
He is highly qualified PhD holder. He is not the PhD.
ಅದೆಲ್ಲ ಕನ್ಸಿಡರ್ ಆಗಿದೆ ಏನೋ
Tribunal has considered all this thing. My learned friend is harping on only that letter, that I have given up, and it is a transfer to abroad.
ಕೊಡಿ ಅವ್ರಿಗೆ ನೋಡಿ. ಅದ್ರಾಗ 21 ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ರೆಫರ್ ಆಗಿದೆ. ಜಸ್ಟಿಸ್ ರಾಮಜೋಯಿಸ್ ಅವ್ರ ಬುಕ್ ಅನ್ನು ರೆಫರ್ ಮಾಡಿದ್ದಾರೆ ನೋಡಿ. ಸುಪ್ರೀಂ 91 ಓದಿ, ಅದನ್ನು ರಿಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದಾರೆ ನೋಡಿ. That was in the absence of 2024, the instrument of the government. ಇನ್ನೊಂದೆರಡು ಪೇಜ್ ತಿರುಗಿಸಿ.
The difference between rule 64 and rule 32 has been considered.
ಆ ರೀತಿ
there is no dispute about that. Only my case is she is given up and only she is entitled to claim that post when it becomes vacant.
A civil servant was appointed to who was placed in the independent charge of the post of the principal.
It's not independent, it is in charge.
In charge post of the principal under rule 32, another
64. Independent adre 32.
Rule 64 of KCSR.
As well as per circular manner, circular dated 10/10/23
is grieving before the writ court against the state administrative tribunal's order dated so and so, whereby new applicant idrana
ಅಲ್ಲಿ ಅವರ applicant,
non applicant,
the private respondent's application number so and so having been favored, comma, the following relief has been accorded to her. Operative portion of the order tribunal. Learned counsel appearing for the Kudvadi, be seated. Learned counsel appearing for the petitioner vehemently argues that the order of the tribunal is liable to be voided in as much as it upsets 50 years service jurisprudence as reflected in Justice Ramajoy's services under the state. Page namesh hakobekan. So and so, semicolon. Seniority is not one of the factors while considering case of candidate for placement by way of in charge or independent charge basis.
but the circular is there,
The third respondent, even if she is placed higher in rank, higher in the select list, comma, both his client and she having been appointed on the same day, comma, that seniority factor pales into insignificance. 7, full stop. Out of his submission, he places reliance on the decision of a learned single judge of this court in Basavaraj and Dhotrad versus Karnataka Land Army Corporation. On which it has been structured.
And the
First
circular issued by the.
Nagarajappa repeats unnecessarily. ಹೇಳಿರಲ್ಲ ನೀವು ಕುತ್ಕೊಳ್ಳಿ ಬರಿತೇವೆ ನಾವು ಕುತ್ಕೊಳ್ಳಿ ನೀವು ಹೇಳಿರಲ್ಲ ಬರಿತೇವೆ ನಾವು ವೈ ಡು ಯು ವರಿ. Learned private counsel places reliance on a government order dated
10/10/23,
10/10/2023, which accords seniority as a factor in the matter of placement of a government servant on in-charge basis in the higher post. First up, he also points out that Dhotrad Supra had no such order of the government, and therefore the law as declared in that would not much come to the aid of petitioner. First up. There is another aspect of both petitioner and the private respondent giving letters about their not being interested in holding the post in question, which we will advert in due course. Okay. Next. Having heard the learned counsel for the parties and having perused the petition papers, we decline indulgence in the matter, in as much as the government order of 2023 specifically stipulates that for a candidate to be placed on in-charge basis in a higher post, comma, seniority is also a factor. This order makes sense in as much as even an employee placed on in-charge basis will exercise some supervisory powers on those ordinarily who work under him or under his office. At times, supervisory and aegis jurisdiction is exercised by the officials of the kind over others, especially when he or she holds the premium post in the institution like the one in question. First, keeping all this, the executive, the government in its executive wisdom has issued that order. First, the tribunal has accorded relief to the private respondent inter-alia on the ground that the said order comes to her aid. First, this reasoning cannot be faltered. Next paragraph. The vehement submission of learned counsel for the petitioner that the private respondent had given a letter dated 20 January 2023 saying that she was not inclined to work in the higher post, in the post of principal on in-charge basis, explaining her own reasons like mental agony by the then colleagues, etc. In sentence, read that. Read the sentence. So and so, comma. And therefore, this aspect ought to have been properly discussed by the tribunal. Full stop. In reply, Mr. Nagarajappa, appearing for the private respondent, draws our attention to petitioner's letter dated
Dated, my lord, 20th of January 2020.
petitioners. Nimdu.
ಅಲ್ಲ ನಮ್ಮದು that 20th of January 23 ಒಂದೇ ದಿವಸನೇ ಇಬ್ಬರು ಕೊಟ್ಟಿದ್ದಾರೆ.
Petitioner's letter evenly dated, in which he too had shown disinterest for the post in question. First stop. A letter and counter letter take away the substance of argument advanced by both the sides to defeat each other. First stop. Be that as it may. First stop. The tribunal, having considered all aspects of the matter, has rendered justice to the cause brought before it, and that does not warrant interference of writ court, in as much as a just result according with the intent and content of government's order dated 2023 has been brought about. Next paragraph. The last submission as to reliance on B.N. Dhotrad is concerned, comma, as already mentioned above, that was the case relating to independent charge under Rule 32 as contradistinguished from the one under Rule 64, 64, semicolon. Secondly, at that time, the government had not issued the order of 2023 kind. First stop. A small difference in fact matrix of a case may render a decision inapplicable as a precedent. First stop. Next, with the above circumstances, this petition being devoid of merits is liable to be and accordingly dismissed, courts having been made. Next. From a Veer Singh.
Kindly pass over the matter. Request Mr. Holla to appear on the matter.
Pass over.
My lord,
Sorry,
kindly-
pass over.
my lord,
Chelsea like
Kindly out next week, my lord. My senior not keeping well, my lord. He can't sit and stand. He's having back pain.
Not well. Charity is not well.
Well, my lord. He's having back pain, my lord.
All right. Call this matter next week, gather on date, buddy. Second. All right. At the request of counsel appearing for the respondent, panel counsel appearing for the respondent. Yes, next. None appears for the petitioner Lokayukta.
Kindly excuse me. Not regarding the question of locus standi. Regarding the question of locus standi, my lord's judgment.
That's what we told, na? What
Division-
has happened in this? What the tribunal has done now?
Also, my lord, one moment. My lord's judgment has been referred and followed in a coordinate bench judgment also
Other judges also.
by Justice Anu Shivaraman and Justice Basavaraj.
Okay.
But the challenge here, Lord, is to, Lord, an order of the tribunal where, my lord, the tribunal would interfere, my lord, with the, where the learned tribunal would set aside the order of penalty of the disciplinary authority, my lord, government, on the ground.
Report of your
Yes.
inquiry report of registrar.
Yes, slight change here, my lord. We recommended, the Honorable Lokayukta would recommend, my lord, for imposition of penalty of compulsory retirement. Honorable Lokayukta would recommend imposition of penalty of compulsory retirement. But this is a misconduct in relation to, my lord, demand and acceptance of bribe amount. The Honorable Lokayukta would recommend the imposition of penalty of compulsory retirement. The disciplinary authority government, my lord, would go ahead and impose that penalty. Annexure A8. Then, my lord, Annexure A9, another order is passed about 1 year later. Under Rule 214A, seeking to, my lord, impose a penalty of 40% withholding of pension.
In substitution of earlier order.
Not a substitution, my lord, because at the by that time he has already, my lord, retired. By the time, my lord, that he has already retired. So, my lord, your lordship may kindly recollect Rule 214A of the KCSR, which requires, my lord, a good conduct. Based on good conduct, my lord, the government
Yeah,
can
good conduct the exercise.
Yes, my lord.
Not for people like this, Santa.
214A, my lord, because, my lord, otherwise the penalty order would have been, my lord, only on paper, because
Criminal case enough.
criminal case not resulted in acquittal.
Is it honorable acquittal or?
Not a case of honorable acquittal.
Not a case.
Not a case of honorable.
Tell it.
My lord, criminal case, my lord, judgment is at Annexure A3, page 48. Lord, but here, my lord, I will take, my lord, to the Annexure A3 judgment. Yes.
ಯಾವ ಗ್ರೌಂಡ್ ಮೇಲೆ acquittal ಆಗಿದೆ ತೋರಿಸಿ.
On the ground that official act is not pending, my lord, at page para 60 at page 100.
Official act was not pending at all.
Not pending anta heli, but now, my lord, in view of
Rudrappa agate.
My lord, PV Rudrappa, my lord, your lordships came to conclusion that none of the witnesses were hostile, and hence, my lord, not on the ground of official here.
Five postulates. Five postulates.
Yes, my lord. My lord, there, my lord, none of the witnesses were hostile. Here, my lord, in view of, my lord, the recent judgment of Honorable Supreme Court in Sita Soren's case, pendency of work is not, my lord, a consideration at all for the purpose of Section 7.
Yeah.
That is on the criminal side, my lord. That 7-judge bench of the Honorable Supreme Court. So, my lord, this judgment tested in the light of that judgment, my lord, whether this is honorable acquittal is what your lordships will consider. Of course, my lord, PV Rudrappa is a guiding factor, my lord, where, my lord, your lordships held. The judgment will have to be read on the whole, not just, my lord, some paragraph, some sentence, some stray sentence. That is what your lordship said in PV Rudrappa's. Of course, my lord, it will be a strong factor for my left and for DGO. Strong factor PV Rudrappa, which
how this aspect is treated by the tribunal?
The tribunal would say on the ground of double penalty. 2 penalties is what the tribunal offers, not on any other aspect. Tribunal at page 160, paragraph 16. It says
penalty alli though.
ಎರಡು penalty ಆಯ್ತು ಅಂತ
penalty ಹೋಗಿ ಬಿಡ್ತದೆ because he retired. ಹಂಗೆ question of compulsory retirement will not arise at all.
Yes,
where is the double jeopardy?
That is what the tribunal would hold, not that double penalty is what is.
How tribunal holds? What is your stand?
When the first what is the date of first imposition?
Compulsory retirement yavaga?
And Annexure A8, date 18/1/2019.
When he retired?
Not the date of retirement, not is that
ತದಿಂದಂಗೆ ಹೆಂಗಿದೆ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ಲಿಕ್ಕೆ ಈ ಡೇಟ್ ಗೊತ್ತಿರ್ಬೇಕು. Suppose if retirement one day, even on the day of retirement in the forenoon, if he is dismissed, then that order is sustainable. An employee can be removed by way of dismissal, discharge, whatever, even on the last day of employment. Double jeopardy, ಹಾಗಾಗಿ ಎರಡು ಆರ್ಡರ್ಸ್ ಅನ್ನು ಸೆಟ್ ಅಸೈಡ್ ಮಾಡ್ಬಿಡಿ.
ಇಲ್ಲ, ಒಂದ್ ಆರ್ಡರ್ ಸೆಟ್ ಅಸೈಡ್ ಮಾಡಿದೆ.
ಯಾವ್ದನ್ನ?
40% pension withholding na compulsory retirement has been
retained.
But by that date not he was already retired. He was not 59 years in 2020 itself.
So now you are seeking reversal of that.
Reversal.
That ಮೊದಲನೇದನ್ನು ಬೇಕಾದ್ರೆ ರದ್ದು ಮಾಡಿ ಎರಡನೇದು ಮಾಡಿ ಅಂತನಾ?
ಅಲ್ಲ, ಎರಡನೇದು ಅಷ್ಟೇ.
But the DG has not challenged not the first order.
ಅಲ್ಲ, ಎರಡು ಮಾಡಕ್ ಬರುತ್ತಾ ಅಂತ?
Blood 214A malad is the discretion of the disciplinary authority.
Correct.
Correct.
ಅದ್ರ ಸಲುವಾಗಿ ಎಲ್ಲಿ ಆಗಿದೆ? ಏನ್ ನೋಟಿಸ್ ಆಗಿದೆ? ಆಮೇಲೆ ಎನ್ಕ್ವೈರಿ ಏನಾಗಿದೆ?
Blood that is recorded malad in annexure A9. Blood this itself annexure A9. Blood this earlier penalty order, earlier inquiry report itself is sufficient. Blood is my respect.
Correct.
For the annexure A9.
ಹಂಗನಿಸ್ತದೆ.
No separate inquiry.
ಸೆಕೆಂಡ್ ಆರ್ಡರ್ ಮಾಡ್ಲಿಕ್ಕೆ ಬರ್ತಿರ್ಲಿಲ್ಲ.
No
ಅವ್ರೇನ್ ಮಾಡಿದ್ದಾರೆ?
Blood annexure A9 blood.
A9 ಪೇಜ್ ಹೇಳ್ಬೇಕು.
Page 136. Relevant portion page 137. May I read blood last paragraph at page 137. ಓದಲಾದ ಕ್ರಮ ಸಂಖ್ಯೆ 8 ಸರ್ಕಾರದ ಆದೇಶದಲ್ಲಿ ಎಂ ವಿ ವೆಂಕಟಾಚಲ ಪ್ರಥಮ ದರ್ಜೆ ಸೊ ಅಂಡ್ ಸೊ ಇಲಾಖೆ ಇವರ
ನಿವೃತ್ತಿಯಿಂದ ಶೇಕಡಾ 40% ಮೊಬೈಲ್ಗೂ. ಯಾಕೆ? ರೀಸನ್ ಏನ್ ಕೊಟ್ಟಾರೆ?
that blood that there is a proposal from the Karnataka Loka Seva Ayoga and that proposal is accepted. ಓದಲಾದ ಕ್ರಮ ಸಂಖ್ಯೆ 9 ಸರ್ಕಾರದ ಪತ್ರದಲ್ಲಿ ಕರ್ನಾಟಕ ಸೇವಾ 214A ರ ಮೊದಲು ಪರಂತುಕದ ಅನ್ವಯ ಕರ್ನಾಟಕ ಲೋಕ ಸೇವಾ ಆಯೋಗ ಸಮಿತಿ ಸಹಮತಿಯನ್ನು ನೀಡುವಂತೆ ಕೋರಲಾಗಿತ್ತು. ಅದರಂತೆ ಓದಲಾದ ಕ್ರಮ ಸಂಖ್ಯೆ 10 ಪತ್ರದಲ್ಲಿ ಎಂ ವಿ ವೆಂಕಟಾಚಲ ಪ್ರಥಮ ದರ್ಜೆ ಸೊ ಅಂಡ್ ಸೊ ಇವರ ನಿವೃತ್ತಿ ವೇತನದಿಂದ ಶೇಕಡಾ 40% ಶಾಶ್ವತವಾಗಿ ತಡೆ ಹಿಡುವ ದಂಡನೆಯನ್ನು ವಿಧಿಸಿ ಸರ್ಕಾರದ ಪ್ರಸ್ತಾವನೆಗೆ ಕರ್ನಾಟಕ ಲೋಕ ಸೇವಾ ಆಯೋಗವು ಸಹಮತಿಸಿದೆ. ಅದರಂತೆ
ಅಲ್ಲ, ಮೊದಲಿಂದ ಕಂಪಲ್ಸರಿ ರಿಟೈರ್ಮೆಂಟ್ ಮಾಡಿದ್ದೆ ಅವತ್ತು.
the previous paragraph milad
1912-2019
2019 ಕಂಪಲ್ಸರಿ ರಿಟೈರ್ಮೆಂಟ್ ಆದ್ರೆ ಫುಲ್ ಪೆನ್ಷನ್ ಸಿಗತ್ತೆ.
ಫುಲ್ ಪೆನ್ಷನ್
ಕ್ವಾಲಿಫೈಯಿಂಗ್ ಪೀರಿಯಡ್ ಇದ್ರೆ. ಇದಾದ್ಮೇಲೆ ಈ ಆರ್ಡರ್ ಮಾಡಿದ್ದೆ. ಸೆಕೆಂಡ್ ಆರ್ಡರ್ ಹೆಂಗ್ ಮಾಡ್ತಾರೆ?
ಸೆಕೆಂಡ್ ಆರ್ಡರ್ milad
once
yes
punishment order of punishment is issued under rule 11 ಅನ್ನೋದು 8 rule 8 ಕೆಳಗಡೆ ಆ ಆರ್ಡರ್ ಮಾಡಿದ್ಮೇಲೆ ಇನ್ನೊಂದು ಪೆನಲ್ಟಿನ ಸೂಪರ್ ಆಡ್ ಮಾಡ್ಲಿಕ್ಕೆ ಪವರ್ ಎಲ್ಲಿದೆ ಅಂತ?
214A it is 2141A that it does not require not a separate inquiry to be held. If the disciplinary authority comes to the conclusion, my lord's concern I am probably trying to understand, Lord, your lordship is hinting at the fact that there is no reference to a notice issued or there is no there I stop, there I pause. If your lordship not would come to that conclusion, if your lordship feels not to find out if notice has been issued.
I am in this matter, my lord, I am appearing for R3. Time may be.
ಏನ್ ಟೈಪ್ ಕೊಡಲ್ಲ.
I have not been served with a copy, only Suyamoto Wakalat has been filed by me. Therefore, copy has not been served to me.
ಯಾರಿಗ ವಕಾಲತ್ ಹಾಕಿದ್ರಿ?
So process has not been taken by them. Therefore, notice has been come to me. Suyamoto, I have filed no wakalat.
How you came to know your client is in wakalat?
As I am sitting in the court hall, that's why. I have moved 2 memos. Today also I moved memo for early hearing.
Early hearing. ಹಂಗಾಗಿ ತೋಳ್ತಾ ಇದ್ದೀವಿ early hearing ಆರ್ಗ್ಯೂ ಮಾಡಿ ಮೆಮೊ ಮೂವ್ ಮಾಡಿದ್ರೆ ಅರ್ಥ you can't say copy is not given to you. You have to argue. We are early hearing now. No time will be granted. Now, how?
Yes, Lord. I will pause. I will not argue, Lord. Between page 137, 138.
Number 1, 2 things I am asking you. One, he has power. Therefore, he has exercised power. The exercise of power is not in accordance with principles of natural justice because he is not heard in the matter. So one aspect. There is no power at all to do that because once you pass order of penalty, you become functus officio.
Yes.
If that is so, where is the justification for passing the second order?
Lord, yes, Lord. Second order, your lordships are aware, my lord, numerous judgments which hold that pension is not a bounty. That's why when I said, my lord, disciplinary authority has the discretion to pass this order. Of course, that discretion will have to be, my lord, it has to pass the.
Where that power was there, that's all right.
Yes.
That is what your DS Nakara.
Yes.
And so Devaki Nandan Mishra versus State of Bihar. These are the question is, they go against you.
Yes, yeah,
They go against
that's
you.
why I said, not, I'll pause. I will not argue any further. Between para 1,
214 ಯಾವ್ದು ಕೆಳಗೆ issue ಮಾಡ್ಯಾರ ಇವರು?
2141A,
1A.
this order is passed.
ಓದಿ ನೋಡೋಣ.
ಇಲ್ಲಿ ಇರ್ತೇನೆ. ನೋಡಿ.
KCSR. KCSR ಅದು?
Yes, ma'am.
CCA. ಅಲ್ಲ.
ಅಲ್ಲ, KCSR.
KCSR. A.
141A, my lord.
One small a na?
Yes, ma'am. Small.
One capital, one small a.
Yes, your lordship
When
may
the
kindly see.
calculation of pension is being made.
For
and
a
before the
moment, my
pension-
lord, your lordship may kindly see. This is part 4, chapter 15. Part 4 deals with ordinary pension.
Correct.
This falls under part 4.
Correct.
Then, Lord, in relation to pension, how the disciplinary authority, the appointing authority would deal with is provided. for
Recovery
under
as
this
a
part.
punitive measure.
Yes. Then, Lord, yes. 214. Yes.
Where is the enquiry? Loss caused to government, etc.
Your lordship is at 2141B. This order is passed under 2141A.
1A.
Yes, withholding or withdrawing pension for misconduct or negligence. The government reserves to themselves the right of either withholding or withdrawing a pension or part thereof, either permanently or for a specified period, if in any departmental or judicial proceeding, the pensioner is found guilty of grave misconduct or negligence during the period of his service, including the service under a foreign employer and service rendered upon re-employment after retirement. For a moment, this your lordships have observed in several other cases. If there is a finding of grave misconduct or not has to be seen in the penalty order.
No, once you pass the penalty order, thereafter you will have one more power to pass this order.
But this is, again, Lord, this is, as your lordship would see, this is the discretion of the government. They reserve the right to themselves. If in any disciplinary inquiry, if the DGO has been found guilty of misconduct, grave misconduct, this is after, Lord, being found guilty.
Being found guilty.
Yes.
And before issuing the punishment.
Lord,
it cannot. Definitely found guilty only. He has been found so guilty.
Yes.
You have awarded punishment. He has been awarded with the punishment.
I agree.
And you say compulsory retirement.
Yes.
They have done that.
Yes, ma'am. Yes, ma'am.
Now KPSC says, no, you recover 40%. But that can the KPSC say now? You know what kind of tamasha the government is doing, we do not understand. Double jeopardy prashne alla idu.
Yes.
Ordinarily, double jeopardy is confined to the criminal proceedings, ordinarily. No person shall be
penalized twice.
At any time ಅಂತಿಲ್ಲ. ಯಾವಾಗ ಬೇಕಾದ್ರೂ ನೀವು ಮಾಡ್ಬೋದು ಅಂತ ಹೇಳಿದೆ.
In any departmental proceedings, if he is found guilty of grave misconduct or negligence during the period of his service, including the service under the employer, so and so, so and so. That has been taken care of. Question is, our impression is based upon good books like Justice Rama's Services under the State, Samaraditya Pal and Law of Public Services, Kulashreshta, vide Kulashreshta on writ remedies and public employment. They are of the view that once the government levies penalty, to review penalty, this is not only, you are adding a penalty. So you are superadding the penalty.
This is basically punitory in nature.
Punitive, pakka punitive.
Punitive.
Yes, my lord.
If it
Section.
is punitive,
No,
then where is the natural justice?
Yes, that is
Or
what
the
I am saying.
other
That is,
person?
but to that, my lord, I would, not to that, I would,
Justice Allah. Natural justice arises where you have power to do, but you do it without hearing the other side.
Like, Even
Where
even
do you
if
have
we
power?
assume that this is independent of the earlier disciplinary proceedings.
ಅಲ್ಲ ಅವ್ರು ಹೇಳೋದೇನು ಅಂದ್ರೆ, ನಿಮ್ಮ ಈ ವಿವನ್ ತಗೊಂಡು ಇವ್ರು ರಿಮೈಂಡ್ ಇಟ್ ಅಂತ ಅವ್ರು ಹೇಳೋದು ರಿಮೈಂಡ್ ಮಾಡಿ ಮಾಡೋದು. You cannot see, Bible says, biblical literature says, God had given an opportunity of hearing to Adam and Eve before punishing them for eating that proscribed fruit in the Eden garden. God is said to have given. One famous book, Vide on administration, Vide and Forsyth on administrative law. What's this actually? If that is so, this is on the assumption that you have, the government has power to do it. What is your power? Once you have issued, levied the punishment in terms of the recommendation of the law. Where is your locus standi?
yes, that also.
ಅವರು ಕಂಪಲ್ಸರಿ ರಿಟೈರ್ಮೆಂಟ್ ಅವರೇ ಹೇಳಿದ್ರು, ಅದು ಕೊಟ್ಟಿದ್ದಾರೆ. You should be more than happy.
Not date of retirement, 31/8/2020. He has not retired, not as on the date of this second penalty also.
He had not retired. Assuming that he had not retired.
31/8/19.
31/8/2020, his date of retirement.
No, we'll assume that he had not retired.
So, my lord, it goes again. If he had retired, my lord, before the date of the
At least
first.
you could have said something.
Imposition is 19, isn't it? 18/1/19.
Your lordship's question, even if there was one day.
On the same day it can be. So for that
Here,
he is
it
answering.
is 31/8/2020. So on that ground, your lordship could.
Correct. This petition by the Lokayuktana, Upalokayukta, by the Upalokayukta, filed under Article 226 and 227 of the Constitution of India, seeks to lay a challenge to the state administrative tribunal's order dated so and so, whereby private respondents' application number so and so having been favored, the penalty of 40% recovery from the terminal benefits, from the pension.
Sorry, Allah, withholding 40%.
Withholding of 40%, whereby the penalty, the punishment order, penalty order of withholding 40% pension has been quashed. First. Next paragraph. Kutuli. Learned senior panel counsel appearing for the petitioner vehemently argues that the tribunal could not have given any relief to the civil servant in question, in as much as the penalty order was made consistent with the recommendation of the Karnataka State Public Service Commission. Semicolon. He also argues that, first of all, Rule 214(1)(a) of KCSR empowers the government to make order of the kind, and therefore this aspect having not been duly considered by the tribunal, there is error apparent on the face of its order. First, so arguing, he seeks allowing of the writ petition. First, learned AGA appearing for the state,
Yes.
for the state makes submission in justification of the impugned order of the tribunal. Enila, you maintain distance because it was your order. And AGA also made her submission in the matter.
I am for the third respondent in this.
The private counsel appearing for the third respondent was a mute spectator in the court and he did not utter one word on the merits of the case, saying that he had no copy of the petition, be that as it may. Next paragraph. Having heard the learned counsel for the parties and having perused the petition papers, we decline indulgence in the matter in as much as in a properly constituted disciplinary proceeding, the private respondent was awarded the punishment of compulsory retirement in terms of recommendation of the petitioner Upalokayukta, except vide order dated compulsory retirement order inadu
19/12/2019.
19. Semicolon. If that be so, we are not sure that the Lokayukta, petitioner Lokayukta has any locus standi nor the locum in the matter.
With lordship judgment in
the light of a coordinate bench decision of this court in Dharwad bench Daladu.
Yes, ma'am. 4 days before that judgment.
ಅಲ್ಲ 3rd September 2020
ಅಲ್ಲ ಅದ್ರಲ್ಲಿ ಲೋಕಸ್ ಇದೆ ಅಂತ ತಾವು ಬರ್ದಿದೆ.
ಅಲ್ಲ ಅದು ಲೋಕಸ್ ಅಂದ್ರೆ ಅದರಲ್ಲಿ ಅಷ್ಟೇ, ಇದು ಅದರ ಬರಲ್ಲ.
ಇದು ಲೋಕಸ್ ಇಲ್ಲ ಅನ್ನೋದು ಇಲ್ಲ ಐ ಆಮ್ ಸಾರಿ, ಐ ಡೋಂಟ್ ಹ್ಯಾವ್ 4 days ಬಿಫೋರ್ ದಟ್ ಯುವರ್ ಲಾರ್ಡ್ಶಿಪ್ ರಿಕಲೆಕ್ಟ್ ರಿಮಾಂಡ್ ಆರ್ಡರ್ ಮಾಡಿದ್ದಾಗ ತಾವು ಲೋಕಸ್ ಇಲ್ಲ ಅಂತ ತಾವು ಹೇಳಿದಾಗ ದಿಸ್ ಈಸ್ ದಟ್ ಬ್ಯಾಚ್ ಆಫ್ ಪಿಟಿಷನ್ಸ್.
ಲೋಕಸ್ ಇದೆ ಅಂತ ಹೇಳಿ
ಲೋಕಸ್ ಇಲ್ಲ ಅಂತ ರಿಮಾಂಡ್ ಆಗಿರೋ ಮ್ಯಾಟರ್ ಅಲ್ಲಿ ತಮಗೆ ಲೋಕಸ್ ಇಲ್ಲ ಅಂತ ಹೇಳಿ ತಾವು
ಇದು ರಿಮಾಂಡ್ ಅಲ್ಲೇ ಇಲ್ಲಲ್ಲ,
ಇದು ರಿಮಾಂಡು ಅಲ್ಲ, ಬಟ್ ಇನ್ ದಿಸ್ ಬ್ಯಾಚ್ ಆಫ್ ಪಿಟಿಷನ್ಸ್ ಯುವರ್ ಲಾರ್ಡ್ಶಿಪ್ ಸೆಡ್
that ಅಪ್ಲೈ ಆಗಲ್ಲ, ಅದೇನು ಅಪ್ಲೈ ಆಗಲ್ಲ because in terms of your recommendation they have done already. ಬರ್ಕೊಳ್ಳಿ. Secondly, once the order of punishment has been issued on the basis of the proven guilt, the government ordinarily does not have power to alter the same in the self-same jurisdiction. Merely because, please be said, merely because the KPSC had recommended punishment of the kind, that cannot be done by superadding it to the order of penalty which the civil servant had already suffered. First, there is nothing in the text of Rule 2141A that runs counter to this. First off. Next paragraph. The tribunal, having considered all aspects of the matter, has rendered the judgment in question, order in question, in favor of the private respondent, who since retired is in the evening of his life. First off. The government cannot act as a despot merely because some other authority made the recommendation. Semicolon. It could have solicited the recommendation of KPSC before it had handed the order of compulsory retirement in December on 19/12/2019. First off, order of successive orders of punishment run counter to the well-established service jurisprudence, canons of service jurisprudence. First, we have not been shown any rule or ruling to justify the contentions that run counter to the reasoning of the tribunal. First off, one more sentence we need to add. And the colon hag. Once the order of punishment is handed, comma, pursuant to proven guilt in a properly constituted inquiry, comma, the competent authority, the disciplinary authority becomes functus officio. Functus officio. And it cannot take up the papers at its hands again for adding or deleting, for modifying the punishment order by addition or by deletion. First, an argument to the contrary would be violative of the principles on which the government as a model employer has to follow wide. Wide apex court decision. Hajarika versus state of Assam. So and so. In the above circumstances, this petition being devoid of merits is liable to be rejected both on locus standi and on merits. And accordingly, it is. Great. KPSC ಯಾರ appear ಆಗ್ತಾರೆ? ಇಲ್ಲ ಪಾರ್ಟಿನೇ ಇಲ್ಲ. Only recommended government. How government will pass make one more order imposing? ನಾಳೆ ಯಾರು ಸೇಫ್ ಆಗಲ್ಲ. At least ಅಲ್ಲ ನೋಟಿಸ್ ಕೊಟ್ಟರು ಬರಲ್ಲ. ಯಾಕೆಂದ್ರೆ ಪನಿಷ್ಮೆಂಟ್ ಗಿಂತ ಮೊದಲು ಕೊಡಬಹುದಿತ್ತು.
That has to be withdrawn. It could have been withdrawn and then
ವಿಡ್ರಾ ಮಾಡ್ಲಿಕ್ಕೆ ಪವರ್ ಇಲ್ಲ.
Review
ಪನಿಷ್ಮೆಂಟ್ ಅವಾರ್ಡೆಡ್ ಅದನ್ನ ಸೋಮುಟ್ಟು ರಿವ್ಯೂ ಮಾಡ್ಲಿಕ್ಕೆ ಬರ್ತದ?
Review powers are there.
ಹೌದಾ?
Yes. Under CCR rules it is there. Review power.
Review by
the government, disciplinary authority.
Governor alva?
Adhe same lord. Rule 18 and 19 of CCA rules.
18, 19 CCA kudi. And review is by the governor.
But the same authority which passed the order. Same authority which passed the order.
ಹೌದಾ? ಹಂಗನಿಸ್ತದ? ಇನ್ನು I don't remember. Rule 18. ಅಲ್ಲಿ ಭೂಪೇನ್ ಹಜಾರಿಕಾ ಅಂತ ಬರಿಬೇಕದು. ಭೂಪೇನ್ ಹಜಾರಿಕಾ ವರ್ಸಸ್ ಸ್ಟೇಟ್ ಆಫ್ ಅಸ್ಸಾಂ.
I am sorry, my lord. Rule 26.
26,
Yes. May I read? That this penalty order is passed under 8 of the same rules.
ನೋಡಿ ಓನ್ಲಿ ಯಾವಾಗ ಗೊತ್ತಾ? ದ ಆರ್ಡರ್ ಇಂಪೋಸಿಂಗ್ ಪೆನಾಲ್ಟಿ ಈಸ್ ನಾಟ್ ಲೀಗಲಿ ವ್ಯಾಲಿಡ್ ಆರ್ ಇಟ್ ಕೆನಾಟ್ ಬಿ ಗಿವನ್ ಇಫೆಕ್ಟ್. ಎರಡೇ ಕಂಡೀಷನ್, ಬೇರೆ ಯಾವುದು ಇಲ್ಲ.
27 is also there.
27.
But the
It is appellate authority's power to review. Where appeal is not filed, still appellate authority can review ಅನ್ನೋ ಅರ್ಥದಲ್ಲಿ ಇದೆ. Same ಅದಕ್ಕೆ ಭಾಳ ಡಿಫರೆನ್ಸ್.
And proviso, my lord, says within 6 months.
ಅದು again it's within 6 months. ಇದಕ್ಕೆ ಪ್ರಾವಿಷನ್ ಇಲ್ವಾ ಗವರ್ಮೆಂಟ್ಗೆ?
but the last part of not just about that ABCD in Rule 26, or if in its opinion, an order imposing any penalty cannot be given effect to, or if an order imposing penalty is not legally
valid.
either
Legally valid ಅಂದ್ರೆ ಅದನ್ನ ತೆಗೆದು ಹಾಕ್ಬಿಡ್ಬೇಕಿತ್ತು.
that not your lordship's reference, 1 day, that will apply. So if it was
even
1 day after the retirement, then it is illegal, so it cannot be
correct.
given.
Therefore, we would
Then
have
it
done
could have
that.
been.
Suppose after retirement they do. Correct. ಅವಾಗ ಬರ್ತಿತ್ತು.
Not in this case. Even with notice, in this case, it could not.
We little restructuring I will do, reasoning, because you brought to our notice 24 and 26. 26 and 28.
That last portion, last sentence, your lordship may have to consider in the light of 26.
26, correct. No rule is brought to our notice ಇದೆಲ್ಲ ಅಲ್ಲಿ ಮಾಡ್ಬೇಕಾಗ್ತದೆ. ಅಲ್ಲಿ no rule ಇದೆಯಲ್ಲ ಅದು ಅಂಡರ್ಲೈನ್ ಮಾಡು. Refer to rule 26 and 28 of KCS ಅಲ್ಲ. Okay.
Great.
ಆಯ್ತಾ? ಯಾವ್ದು ಇಲ್ಲ.
Yes, sir. Huh? Intern. I have a son. He's. Oh.
ಮ್ಯಾಟರ್ ಇದೆ. ಒಂದ ಸೆಕೆಂಡ್, ಒಂದ 2 ನಿಮಿಷ.
ಬಡಿ. ಹಾ. ಏನು ನೋಡಿ ಈಗ?
EMCPC matter, the lower court proceedings are stayed for the past 4 years. And for the petition,
4 years.
4 years is stayed.
Next Friday ಹಾಕೋಣ.
Lots.
ನಮ್ಗಿಲ್ವಾ GMCPC? ನಮಗೂ ಇದೆ. Whenever we see it. ಅದು ಹಾಕಿ ಯಾವಾಗ ಸಿಕ್ಕದು. All right.
My lords, if I may, my lords. Serial number 6, my lords, if I can seek for a short accommodation, my lords. 6, my lords.
ಏನು?
My lords, I've recently 2020 matter, my lords.
I'm for the petitioner.
I'm for the petition.
Yes.
You want time?
Lords, in fact, I'm seeking for time, my lords. I've recently received the file, my lords. Newly entered appearance on behalf of the department, my lords.
ಕೊಡ್ಬೋದಾ? 2 weeks?
2 weeks, my lords.
After vacation.
It's 2 weeks. Any date that's convenient to this honorable court, my lords.
ಅವ್ರಿಗೆ ಕೇಳಿ ನಿಮ್ಮ ಕೌನ್ಸಿಲಿ. ಯಾರೋ
JK Mittal ಅಂತ.
Mr. Victor?
Yes, my lord. Yes.
He
my
wants,
lord.
your friend wants some time. Can we call this
yes,
in the second week of January 25?
It would be fine, my lord. Only indulgence, I once condonation was already allowed, my lord. Still it is showing in the cause list.
ಅದು
It
delay
was
11
allowed.
days condone ಮಾಡೋಣ.
My lords, I believe it's
It
already
was already
condoned.
allowed.
It's already been condoned.
Already condoned.
It's already condoned.
Already condoned.
25th
condoned.
November 2021. Yes,
Yes, sir,
yes,
it
my
is
lord.
already condoned. Call this
Yes.
matter
Yes.
in the second week of January 25 at the request of. Yes,
Much obliged.
great.
Grateful, my lord.
All. ಶಿವಪ್ರಕಾಶ್, ಇದು ಹೊಸ ವರ್ಷಕ್ಕೆ ಹಾಕೋಬೇಕು ನೀವು.
ಅಲ್ಲ, ನಿಧಾನ ಮಾಡಿದಷ್ಟು ನನಗಿನ್ನ ಹೆಚ್ಚಾಗಿ ಮೆಟೀರಿಯಲ್ ಸಿಗ್ತಾ ಇದ್ದಂಗೆ ಆಗಿದೆ. ಅವ್ರೇನಾದ್ರು
ಇದು ಸ್ವಲ್ಪ ಈಗ ಬಿಫೋರ್ ವೆಕೇಶನ್ ಡಿಫಿಕಲ್ಟ್. ನಾವು ಯಾವ್ದಾದ್ರು ಪಾರ್ಟೆಡ್ ಮ್ಯಾಟರ್ಸ್ನ ಎಲ್ಲ ಇದ್ಬಿಟ್ಟಿವಿ. ಬೇರೆ ಬೇರೆ ಬೆಂಚಸ್ನಲ್ಲಿ ಇದ್ದೀನಿ ನಾನು. ಹಿಂಗಾಗಿ ನಿಮ್ ಕ್ಲೈಂಟ್ ಹೇಳಿ ನಮಗೆ ಅಜರ್ಮೆಂಟ್ ಕೊಡಿಸ್ಬೇಕು ನೀವು.
ತಮ್ಮ ಒತ್ತಡ ಎಲ್ರಿಗೂ ಗೊತ್ತು, ಈ ಕೋರ್ಟ್ ಒತ್ತಡ ಏನು.
ಬೇರೆ ಬೇರೆ ಕಡೆ ಇದೆನಲ್ಲ, ಹಂಗಾಗಿ ವೆರಿ ಡಿಫಿಕಲ್ಟ್ ನಮಗೆ.
ಸ್ಪೆಷಲ್ ಕೋರ್ಟ್ಗಳೇ ಬಳಸ್ತಿದ್ದ.
ಫಸ್ಟ್ ವೀಕ್ ಆಫ್ ಜನವರಿ ಹಾಕೊಳ್ಳ
ಆಗ್ಬೋದು. ಡಿಸೆಂಬರ್ ಅಲ್ಲಿ ಏನೋ ಅವಕಾಶ ಇದ್ರೆ ಒಂದು ಅವಕಾಶ ಕೊಟ್ಬಿಟ್ರೆ
ನೋಡ್ರಿ, ಯಾವ್ದಾದ್ರು ಮಂಡಿ ಹಾಕೊಳಿಕ್ ಬರ್ತದ. 13th of December. We'll try. All right. Okay. All right. Matter adjourned by court suo motu to 13 December for want of time. Yes.
Need a copy, my lord. A copy of the order of your lordship's order has reached only on 30th July. The officer, my lord, had transmitted record to the trial court on 3rd August. The trial court, my lord, rejected, saying that it's already 3 weeks have lapsed.
ಏನ್ ಮಾಡ್ಬೇಕು?
Take some time, my lord, then we'll place.
2 weeks?
Agbodu. It's in fact ready. We placed it, but the trial court refused to take it, saying that you come after lapse of time.
Delay booked in filing that application another.
Alla, we were supposed to file the complaint fresh.
ಆ period expire ಆಗಿತ್ತು.
ಹೌದು. Trial court should have accepted it because we have informed the trial court saying that we received the copy on 30th July. In fact, we showed the acknowledgement also, but the trial court seems to be.
This court-wide order dated 5/7/2024, whilst disposing of the revision petition, criminal petition, had prescribed the period within which
So this is the lordship.
the police were required to remit the papers.
The lordship recall, the charge sheets were filed for 188, and we cannot file a charge sheet, we have to file a complaint. So that is where your lordship has given liberty to file on 195.
To remit the papers. Those papers were remitted with delay.
Yes, madam, because we received it on order of this.
Because of the delay in receiving of the order copy.
Yes, ma'am. In fact, we did it in 1 week's time.
Within 3 weeks ಅಂತ ನಾವು ಹೇಳಿದ್ವಿ, ಆ ಪೀರಿಯಡ್ ಮುಗಿದು ಹೋಗ್ಬಿಟ್ಟು.
ಮುಗ್ದೋಗಿ ನಮ್ ಕಾಪಿ ಬರಕ್ಕೆ
Said as under ಅಲ್ಲಿ ಪೇಜ್ 4 ನಲ್ಲಿ the jurisdictional police shall ಅಂತಿದೆ ಅಲ್ಲ, ಅದು ರಿಪ್ರಿಂಟ್ ಮಾಡಬೇಕು. First, learned additional SPP submits by the time certified copy of the judgment was obtained, comma, the period prescribed had expired and therefore there was delay in remitting the papers in time. Semicolon. According to him, that delay ought to have been condoned by the court itself, court below itself, and papers ought to have been accepted. And that having not been done, an appropriate direction needs to be issued to the learned magistrate. First off, there is force in this submission. Next paragraph. It hardly needs to be stated that for the delay brooked in obtaining copies of the orders need to be condoned in terms of principle enacted under section 14 of the Limitation Act or on akin principles. First, therefore, learned judge is requested to accept remittance of the papers, if necessary, by condoning the delay. Again, if first, ordered accordingly.
Gratefully.
Next. Yes, Govindra, comment.
Revision petitioner, my lord. ಇದರಲ್ಲಿ ಮೂರ್ IA ಇದೆ ಸ್ವಾಮಿ. To bring LRs on record and the condonation of delay and abatement ಅಂತೇಳಿ ಇದು ಡಿಸ್ಪೋಸ್ ಆಗ್ಬೇಕು.
ಅಪ್ಲಿಕೇಶನ್ ಸಲೋ ಮಾಡೋಣ. ಬರ್ಕೊಳ್ಳಿ. Respondent number 9 ಅಲ್ಲ?
ಹೌದು ಸ್ವಾಮಿ.
Having died, comma, 3 applications have been moved, which one for condonation of delay in filing the LR application, semicolon, the other, another for setting aside abatement, and yet another
to bring
for
LRs.
bringing the LRs of the deceased on record to represent his estate. First, all the 3 applications are supported by separate affidavits.
Yes, sir.
Separate affidavits. First, reasons are plausible reason is assigned, plausible explanation is offered for the condonation of delay, and therefore delay brooked in filing the LR application is condoned.
Yes, ma'am.
Explanation is also offered as to why the abatement should be set aside, and therefore the statutory abatement is set at naught. First off, this eventually leads to allowing of the other application, granting leave to the review petitioner to bring the LRs of deceased on record immediately. ಮಾಡಿ ಮುಗಿಸಿ.
In the meantime,
all 3 applications.
In the meantime, I had filed amended petition also. That is taken on record. It's already is on the file now.
ಏನು amendment petition ಗೆ?
After bringing the LRs on record, I have presented the amended.
ಮಾಡಿದಿರಾ?
Already file.
ಇದನ್ನ amendment ಮಾಡಿ cost title. 2 ಮಾಡಬೇಕು. You have to amend the cost title, file the amended cost title.
ಅದನ್ನಿದೆ.
ಹಂಗಿದೆ. 2 ಇದೆಯಾ?
ಹೌದು ಹೌದು.
Amend ಆಗಿದೆಯಾ ಈಗ?
Cost title amend ಮಾಡ್ಬೇಕು ಸರ್.
ಮಾಡಿ.
ಇಲ್ಲ application amended petition file ಮಾಡಿದ್ದೆ ಸರ್.
ಅದು ಸಾಲಲ್ಲ.
I'll carry out the physical amendment.
Amend ಮಾಡಬೇಕು.
ಮಾಡ್ತೀನಿ ಸರ್.
That is the law. ಕೊಡಿ ಮಾಡಿ ಈಗಲೇ ಮಾಡಿ.
ಆಗ್ಬೋದು ಸರ್.
Call out. ಏನು? Steps to be taken in respect. ಅದೇನು await ಅಂತಿದೆ? or 19 ga. Steps to be taken in respect of or 19 by way of emergent notice within 3 days, within 1 week, failing which petition stands rejected, cause being indivisible. Okay.
I'm for petitioner, my lord.
Ah.
In this matter, your lordship has already allowed that application, my lord, on 19/7/2024. And I have
Alva.
amended the cost title also.
ಆಗಿದೆ ಅಲ್ವಾ ಮತ್ತೆ ಪೋಸ್ಟ್ ಆಗಿದೆ ಆಲ್ರೆಡಿ ಆರ್ಡರ್ಸ್ ಆರ್ ಪಾಸ್ಟ್ ಆನ್ ಅಪ್ಲಿಕೇಶನ್ ಇನ್ ಐ ನಂಬರ್ 1 of 2024 ಫಸ್ಟ್ ಸ್ಟಾಪ್ ಬಟ್ ನಾನ್ ಕಂಪ್ಲೈನ್ಸ್ ಏನದು
That also overruled on last hearing date, my lord, on 19/7/24.
the non-compliance objection is not sustainable since it is already overruled. Okay. Next. Call after 2 weeks. Much. Next.
See, 1 week time maybe. Next step to respond number 3.
You want 1 week?
Respond number 3.
All right.
End time.
2 weeks at the request of learned GA. Steps to no?
R2, R3.
Steps to be taken in the meanwhile in respect of R3. Next.
Is complied, my lords. Already complied.
Compliance ಆಗಿದೆಯಾ?
Lord, that matter now set down for evidence, my lords. This is on 27, my lordship already forwarded the copy to the Registrar General of High Court.
ಏನ್ ಕೊಡಿ ಏನು ಯಾಕೆ ಪೋಸ್ಟ್ ಆಗಿದೆ ನಾನ್ ಫೈಲಿಂಗ್ ಆಫ್ ಕಂಪ್ಲೈನ್ಸ್ ರಿಪೋರ್ಟ್
Refer ಮಾಡಿಲ್ಲ ಅಂತ.
Compliance
Already
ಆಗಿದೆಯಾ?
ಆಗಿದೆ compliance.
learned GA AGA submits the compliance is already done ರಿಪೋರ್ಟ್ ಮಾಡಿಲ್ಲ
Report ಅದು wrong ಆಗಿ Advocate General Office instead of Registrar of General.
and therefore the question of arresting and detaining third respondent would not arise. First, I agree with this. Okay. Next.
I'm for the petitioner.
Secretary.
Right, my lord, the order dated 29/11/2022. The R3 died on 14/3/2021 itself. That's why your lordship was, it has to be recalled. Now legal errors are before the court.
What
happened, my lord? The
the
learned counsel who was appeared there, he did not inform me about the.
ಅವ್ರಿಗೆ ಗೊತ್ತಿದ್ದು ಇನ್ಫಾರ್ಮ್ ಮಾಡಿ
He was not aware of. Now the legal errors are.
ಎಲ್ಲರ ಅಪ್ಲಿಕೇಶನ್ ಅಲೋ ಆದ್ಮೇಲೆ ಏನಾಗಬೇಕು
Then I have to review, I have to pursue. But
After I have to amend,
I have to
amend the petition and my LRs are permitted to brought on record, then matter has to be heard.
application in I number 1 of 2023 supported by the affidavit seeks condonation of a short delay of 6 days in filing the review petition.
Correct.
Filing the review petition is condoned. First, permission
to pursue this by the legal errors, to pursue the review petition. Now, because it's against a dead person, my lord, that our respondent number 3.
LRs has to be permitting the petition.
ಅವ್ರು ಅಲ್ಲಿ ಮಾಡಬೇಕು
ನಾನ್ ಮಾಡ್ಬೇಕು.
Petition
Permitting the
ಮಾಡ್ಬೇಕಾಗ್ತದೆ.
LRs to bring the, and I have to file the amended petition, then my lord.
Correct,
your lordship
you are
has
right.
to-
That's a recall.
ಅಲ್ಲ ಆ ಪ್ರಶ್ನೆ
ಅಂದ್ರೆ ಈಗ
recall
it will be
ಎಲ್ಲಿ
restore ಆಗ್ತದೆ. Writ petition restore ಆದ್ಮೇಲೆ ನಾನು amendment petition ಹಾಕಿ
Recall
ಅವ್ರು
ಮಾಡ್ಬೇಕು.
brought on ಮಾಡಿ.
recall ಮಾಡೋಣ
Please.
recall. Having heard the learned counsel appearing for the parties and having perused the petition papers, comma,
On account of
the
the death.
order having been passed against the dead person, comma, the judgment whereby WP 11411 of 2014 was disposed of stands recalled. First off, permission is accorded to the writ petitioner to bring a loss of the deceased
Respondent number 3.
respondent number 3 within
And to-
2 weeks.
2 weeks.
Within 2 weeks.
And to file the amended petition also.
Huh?
And also.
ಅಲ್ಲ, ಅಲೋ ಆದ್ಮೇಲೆ ಮುಂದೆ
Please, please.
call after 2 weeks.
Please.
Yes. ಅದು ಕಾಲ್ ಆಫ್ಟರ್ ತೆಗೆದು ಪೋಸ್ಟ್ ಆಫ್ಟರ್ ಯಾರ ಮುಂದೆ ಬರುತ್ತೆ ನಮ್ಗೆ ಗೊತ್ತಿಲ್ಲ ಅದು ಪೋಸ್ಟ್ ಆಫ್ಟರ್ 2 weeks ಬಿಫೋರ್ ದಿ ರೋಸ್ಟರ್ ಡೇ ಆಯ್ತು ಪಿಟಿಷನ್ ಡಿಸ್ಪೋರ್ಡ್ ಆಫ್ ಅಷ್ಟೇ. ಯಾರ ಮುಂದೆ ಹೋಗತ್ತೆ
After hearing the LRs, my lord, if it also within the domain of LRs.
ಇಲ್ಲ ಗೊತ್ತಿಲ್ಲ ನಾವು ನೋಡೋಣ. ಅದ ರಿಜಿಸ್ಟರ್ ನಮ್ಮ ಮುಂದೆ ಬಂದ್ರೆ ನಮ್ಮ ಮುಂದೆ.
Please.
ಹ್ಯಾಪಿ, ನೋ ಪ್ರಾಬ್ಲಮ್. ಎಸ್. ಹಾ.
Matter, my lordship, 1 week time may be given. This is
ಏನದು?
only,
ಕೊಡಿ.
lordship, principal amount is already given, my lordship.
Huh?
Only 18% interest on the hearing officer, my lordship. There was no part from the officer. That is why.
ಮತ್ತೆ ಲೇಟ್ ಆಗಿದೆ ಕೊಡು. ಆಫೀಸರ್ ಫಾಲ್ಟ್ ಇಲ್ಲ ಅಂದ್ರೆ
Waive of the cost ಅಂತ ಕೇಳ್ತಾರೆ.
Huh?
Waive of the cost. 18%.
ಎಮರ್ಜೆಂಟ್ ನೋಟಿಸ್ ತೊಳಿ. ಅವ್ರಿಗೆ ಆಗಿದೆ ಏನದು ಸರ್ವಿಸ್ ಆಗಿಲ್ಲ. ಎಮರ್ಜೆಂಟ್ ನೋಟಿಸ್ ತೊಳಿ
Please.
ಬಂದ್ಮೇಲೆ ನೋಡೋಣ. ಎಮರ್ಜೆಂಟ್ ನೋಟಿಸ್ ಎಷ್ಟೇ ನೋಡಮ್ಮ. ಎಂಟ್ರಿ ಮಾಡರ್ the application in IA number 2 of 2023 supported by the affidavit. IA number 2 of 2023 is supported by an affidavit. First off, it seeks stay of the order in question, order put in review. First off, a case is moved out for grant of interim order and accordingly, the said order is stayed till next date of hearing. Weighed in WP number, so it's okay. All right, next.
I am appearing to the respond number 3 in this matter, my lord. The copy of the review petition has not been served.
Murali kelidre, Murali would have given you
I-
one copy and one coffee also.
I saw it.
Murali could have.
had sent through emergent notice, my lord. I don't know why.
Only we
To
have
the-
received the
Padi-
notice. that-
ಕೊಡ್ತೀನಿ ಅದಕ್ಕೇನು
ಅದೇನಾ delay 68 days done condom ಮಾಡೋಣ.
I leave it to your lordship.
Okay. Application in I number 1 of 2023 supported by the affidavit seeks condonation of short delay of 68 days in filing the review petition. First off, plausible explanation for the delay proved having been shown, comma, the same is condoned. Okay, copy kodi.
ಕೊಡ್ತೀನಿ
Obliged.
Next, all after 2 weeks.
My lordship. This is my.
ಏನಿದೆ?
This is my
ಗೋಪಾಲಕೃಷ್ಣ
lordship
ಮೂರ್ತಿ.
government petition. The petitioner in the writ petition, my lordship, she claimed that she is the owner of that property. Before that 1980 itself, my lordship, her husband is sold the property to someone. Your lordship direct.
ಇದೆ.
Kindly see, my lord.
detail ಇದೆ.
Please. In party 2, my page. Her husband is sold the property. In column number 6. Annexure D. my. Mohammed Hussain ಅನ್ನೋರ್ಗೆ ಸೇಲ್ ಮಾಡ್ಬಿಟ್ಟಿದ್ದಾರೆ before claiming that.
6 ಸದಾಶಿವಮೂರ್ತಿ.
He is the her husband, Girjamma husband.
Muhammad Hussain sold it to
No, Sadasivappa sold it to Mohammed.
Muhammad Hussain.
Yes,
27/3/1970 itself.
please, my lord. Without my lordship
But
brought to this notice.
Kindly similar. They themselves have issued the receipt and patta also in the name of the Girijama, that is respondent herein. After the death of my husband, that is in the year of 2020. But they themselves have issued the patta.
No, that's all
RTC,
right, but he had sold
everything.
the land already.
No, my lord. My lord,
ಎಲ್ಲಿದೆ ಸೇಲ್ ಡೀಡ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿ.
Lord, they are saying that, Lord, inter.
ಸೇಲ್ ಆಗಿದೆಯೋ ಎಲ್ಲೋ ನೋಡಕ್ಕೆ ಸೇಲ್ ಡೀಡ್ ಬೇಕು.
ಅದೇ.
ಆರ್ಗ್ಯುಮೆಂಟ್ ನಿಂದ ನೋಡ್ಲಿಕ್ಕೆ ಬರ್ತದ ಸೇಲ್ ಡೀಡ್ ಅಂತ.
Please.
ಬಿಡಿಬೇಕು. Produce the learned GA is directed to produce the sale deed dated 27/3/1970, whereunder the husband of the petitioner, Mr. P. Sadashiva Murthy, is said to have sold the subject land in favor of Muhammad Hussain,
And
comma, since
my lord,
the
again, there,
said sale is denied by the learned counsel appearing for the respondent.
Madam,
First off, non-production of a copy of the sale deed on the next date of hearing may result into dismissal of the review petition.
and moreover, my lord, it is their further contention that, my lord, in turn, Muhammad Hussain, he has sold the property to one Mr. Rudrappa.
ಒಂದು ಇದು ಬಂದ್ಬಿಟ್ರೆ ಸಾಕು ನಮಗೆ. ಅದಾಯ್ತು ಅಂದ್ರೆ ನಿಮ್ ಕೇಸ್ ಹೋಗ್ಬಿಡ್ತದ ಅವಾಗ. ಎಸ್ ನೆಕ್ಸ್ಟ್. ಇದು ಸಬ್ಸೆಕ್ವೆಂಟ್ಲಿ ಅವರ ಇದ್ರು ತೊಂಬನ್ನಿ
Please.
ಅಲ್ಲಿ ಸೇರ್ ಮಾಡ್ಕೊಂಡು ಕೇಳಿದ್ರೆ
Serial number 11, my lord. Appearing for the petitioner, my lord. We have filed an application under section 152 of CPC seeking correction of order dated 17/4.
I have not served the copy, so I am not aware about that. What correction they have sought for?
We have already served the copy, my lord.
ಡಿಸ್ಕ್ರಿಪ್ಷನ್ ಆಫ್ ಲ್ಯಾಂಡ್ ಬೇಕಷ್ಟೇ ಪ್ಲೀಸ್ ಅಲ್ಲಿ ಒಳಗಡೆ
ಹಾ,
ಇದೆ
ಹೌದು.
description ದಲ್ಲಿ.
ಸರ್ವೆ ನಂಬರ್ ಮತ್ತೆ ಮೆಜರ್ಮೆಂಟ್ ನ
All right, all right.
ready, my lord.
All right, all right. Application seeks introduction of some details of the land in question at the ultimate para of the order whereby the writ petition was disposed of. Full stop. The subject land is described as measuring 4 acres in survey number 115 of 2004. 115 of 4. 115 bar 4.
4.
Situated ಅನ್ಬಾರ್ದು ಮನುಷ್ಯ ಇಟ್ರು ಮಾತ್ರ situated. What all God has placed? Situate. Artha point?
Yes, ma'am.
Therefore, in
Yes.
Transfer of Property Act, all sections use the word land is situate. Artha
Yes,
point?
my lord.
Okay.
Yes.
Situated Kergalli village, Jayapura Hobli, Mysore Taluka. At the page 3. At the ultimate paragraph of the order, first off. Necessary correction to be made and free copy of the order be supplied if applied for.
Much obliged, my lord.
Yes, you argued well.
Thank you, my lord.
All right. Next.
Hearing for the proposed respondents, minutes. May I seek a short indulgence? I believe the office has raised certain objections. I will comply with them in a week's
Recalling
time.
the order dated 6/9/22, ಏನದು?
Please, my lord, it was my lord's order disposing.
That we had filed a review petition. Your lordship had allowed the review petition. I think now after 2 years, they've filed, I don't know, some third party, I believe, have filed application to recall, and I think. there are some-
Recalling.
May I request a date be set, my lords? I'm led by Dr. Sondi in this matter. I'll comply with these objections. Bring the proper file before this court. My lords may set a date for hearing is my only request.
This review petition has been disposed of.
Please.
Disposed of.
Recalling the review petition order.
Please, my lord, certain shareholders, my lords, I represent, and those I have filed an application for impleading. We believe, my lord, certain information ought to have been brought to my lord's knowledge, which was not in the matter. Hence, our endeavor will be to show that may be necessary to be considered in the order. That will be our
Alla.
only endeavor.
Whether review of the reviewed order is permissible?
I'll examine, my lords. I'll have to examine.
ಅದಕ್ಕಿಲ್ಲ.
Please,
ನೋಡ್ಕೊಂಡು ಹೇಳಿ. Conflicting judgments ಎಲ್ಲ ಇದೆ ಅದರ ಮೇಲೆ.
please.
Copies also have not been served.
ಕೊಡಿ.
I'll comply and I'll serve them a copy. Please. May I request, subject to my lords, any date, if possible, my lords, of course, I'm.
ಅದು ಡಿಲೇ ಎಲ್ಲ ಏನೇನೋ ಇದೆ ಅಲ್ಲ ಅದು.
I'll do it within a week's time.
All right.
Only.
If compliance is done, post before the court immediately. Okay, please.
Petitioner. Appear for the petitioner.
Yes, ನಿತ್ಯಾನಂದ ಏನಿದು?
Lord, Ready. The original suit, my lord. The plaintiff is the review petitioner, my lord.
Plaintiff is he was respondent in the WP.
Respondent in the WP, my lord. The writ petition, the original suit was filed. Challenging the order passed by the, passed for referring the case to the enhancement of the compensation, as the same suffers from error of jurisdiction, and it was passed beyond the period of limitations prescribed under section 18(3), my lord, 90 days.
90 days.
Please, my lord. Much prior to the filing of that reference application, my lord, the erstwhile land owner approached this honorable court by filing the
by filing the writ petition.
Repeat.
Under the, before
Much
filing,
before.
before filing the reference application, my lord, belated reference application, erstwhile landowner approached this honorable court in the writ petition, challenging the entire acquisition proceedings in respect of 7 acres of their land. Entire extent acquired for the house building cooperative society was 72 acres. Out of that, only in respect of 7 acres, they have approached this honorable court and challenged the entire acquisition proceedings and the award passed. My submission is, as on the date of filing the writ petition and dismissal of the writ petition, they were aware of the award passed. Even thereafter, after lapse of 3 years, they filed the reference application. And in the before the reference court, that was pending for consideration on the evidence matter. One fine day, contrary to the settled norms, my lord, the additional district government pleader files a memo in the registry of the civil court saying that they have received the amount on so and so date, and hence the application filed is within the period of limitation. And solely based on that memo, the reference court has passed the order for referring the case.
It was time barred already.
Time barred by that time. Only solely based upon that memo, the reference court has passed the order, and the amount was enhanced to from 50,000 to 6 lakhs something, my lord. And in fact, I am the member of the society, my lord. Ultimately, as per the sale deed, I am entitled to bear the proportionate expenses. So far as the payment of the enhanced compensation is concerned, my lord. My humble submission is, fraud vitiates everything. Fraud has been committed, and this honorable court in the review, in the order under review was in the original suit, my lord. The landowners have filed an application
Off ಮಾಡಿ. ಅದನ್ನ ಆಫ್ ಮಾಡಿ ಆನ್ಲೈನ್ ಎಲ್ಲ ಆಫ್ ಮಾಡಿ.
The
ಆನ್ಲೈನ್ ಎಲ್ಲ ಆಫ್ ಮಾಡಿ. ಎಸ್ ಓನ್ಲಿ ಹೇಳಿ ಇದ್ದರನ್ನಷ್ಟೇ ಹೇರ್ ಮಾಡೋದು ನಾವೆಲ್ಲ ಡಿಸ್ಟರ್ಬ್ ಆಗ್ತದೆ. ಎಸ್.
In the original suit, I filed an application for stay of proceedings in the execution case. That was allowed. Ex parte order was passed. The defendant landowners have filed an application for vacating the same. Simultaneously, they have filed an application under Order 7 Rule 11 for rejection of the plaint. That Order 7 Rule 11 application came to be rejected, and similar contentions were urged in both the applications. And the application filed for vacating the interim order, staying further proceeding to execution, that came to be dismissed. Against that order, the landlord approached this honorable court by preferring the writ petition, my lord. And in the writ petition, my lord was pleased to adopt, considering the doctrine of proportionality, was pleased to permit the defendant to proceed with the execution proceedings, except the interest of the plaintiffs. My humble.
What is the error in this matter?
My lord was pleased to.
It is a very considered judgment.
Please, my lord, considered decision, and relying upon the doctrine of proportionality, and so far my lord was pleased to allow the execution proceedings to go on, except the interest of the plaintiffs, my lord. My humble submission is, plaintiff's case is not that the fraud has been selectively committed insofar as the plaintiff's land alone. And the virus of fraud cannot be considered in isolation or selectively insofar as the plaintiff's interest is concerned, my lord. And the plaint is pending, and original suit is still pending. Issues are framed, my lord.
Fraud ಇದೆಯಾ ಅದರಲ್ಲಿ?
100% fraud ಇದೆ ಸ್ವಾಮಿ.
ಅಲ್ಲ, fraud issue ಬೇಕು ನಿಮ್ಮ.
Issues ಇದೆ, fraud issues.
ಎಲ್ಲಿದೆ?
May I read, my lord? Whether the plaintiff.
ಆ suit ಏನದು? Which is that suit?
In this suit only, I am the plaintiff, my lord.
Suit.
Please.
That execution proceedings arise from which that's decree in that suit?
Against the order, against the award which was challenged in the suit, my lord. In the suit, I have challenged both the order passing the reference application, allowing the reference application, as well as the award.
May I intervene, my lord?
Yes.
My lord, in this,
the similar writ petitions were filed. This honorable court has dismissed all the writ petitions saying that what is contended by the petitioners are not correct, and the writ petitions are dismissed. Execution petitions were continued, and the dismissal order was not challenged by the society, by which he claims to be one of the members before the Supreme Court, which has confirmed, and now the execution petitions are going on.
Yes.
So under these circumstances, my lord, this RP is, my lord, has almost become infructuous.
My lord, page 19 of the review petition, my lord, the relief sought in the OS, my lord.
What is your locus standi because of Satish Kumar Gupta case, 2017 4 SCC?
Yes.
You are not an
yes.
aggrieved person at all.
And I am an allottee of the two.
You allottee is not an aggrieved person.
My lord, with great respect, when that decision, my lord, relied upon my learned friend in the while arguing the case in the writ petition, my lord. And my lord was pleased to consider this issue in the under the
Against you?
Not against me, my lord.
Huh?
Except in the case of fraud, that a word is used, my lord, in that decision, my lord.
But fraud is not established.
Allottee, my lord, please.
Fraud is not established anta ನಾವು finding record ಮಾಡಿದ್ದೇನೆ.
ಫ್ರಾಡ್ ಇಸ್ ನಾಟ್ ಎಸ್ಟಾಬ್ಲಿಷ್ ಅಂತ ರೆಕಾರ್ಡ್ ಮಾಡಿಲ್ಲ ತಾವು. ಚಂಗಲರಾಯ ನಾಯ್ಡುದಲ್ಲಿ ಬೇರೆ ಕೇಸಲ್ಲಿ ಫ್ರಾಡ್ ಅಂತ ಏನ್ ಹೇಳ್ತಾರೆ, that has to be adjudicated in the original suit. That is the observations made by this honorable court, my lord. Ultimately, this honorable court comes to the conclusion that there should have been adjudication with regard to the fraud on court, misleading, misrepresentation.
ನೀವು ಸೂಟ್ ನಲ್ಲಿ ಏನ್ ಚಾಲೆಂಜ್ ಮಾಡಿರಿ?
Page number 19, my lord.
ಸೂಟ್ ಹೇಳಿದ್ರಲ್ಲ ಈಗ?
Page 19.
19
19.
ಏನು what is that you have challenged in that?
Wherefore, the plaintiff prays that this honorable court be pleased to pass a judgment and decree in favor of the plaintiff as against the defendant number 1 to 12, declaring that the application under section 18(1) of the Land Acquisition Act filed on 19/6/1997 by the first defendant herein and his since deceased brothers Nanjappa and so were hopelessly barred by time, consequently granting a decree of declaration that the order of reference dated so and so passed by the principal senior civil judge in so and so Mysore as null and void ab initio and non-est in the eye of law, consequently declaring that the awards and decrees enhancing the compensation so and so are also null and void ab initio non-est in the eyes of law.
No, you say the reference and online stop ಮಾಡಿ. Online stop ಮಾಡಿ.
Under the Land Acquisition Act, my lord, under the Central Act, 120 days is prescribed.
How can you maintain a suit for that?
I
cannot maintain a suit.
So far as the reference order is concerned, MFA is not.
ಸ್ವಲ್ಪ ಕೇಳ್ಕೊಳ್ಳಿ. ಅಲ್ಲಿ ರೆಫರೆನ್ಸ್ ಫೈಲ್ ಮಾಡಿದಾಗ if application is filed for condonation of delay, it is for the reference court to say whether delay is condonable, whether explanation shown for condonation of delay
My lord,
is accepted.
the legislature.
ಮುಗಿಸಿಲ್ಲ sentence.
Sorry, my apologies. Sorry,
Sentence is not over.
sorry.
ಈಗ ಒಂದು ಅಪೀಲ್ ಹಾಕ್ತಿರಪ್ಪ ನೀವು, ಒಂದು RFA ನಮ್ಮಲ್ಲಿ ಹಾಕ್ತೀರಿ, ಅಲ್ಲಿ ಒಂದು ಡಿಲೇಡ್ ಅಪೀಲ್ ಇರ್ತದೆ, ಹಾಗಾಗಿ ಒಂದು ಅಪ್ಲಿಕೇಶನ್ ಆಗ್ತದೆ ಕಂಡೋನೇಷನ್ ಆಫ್. ವೆದರ್ ಡಿಲೇ ಶುಡ್ ಬಿ ಕಂಡೋನ್ಡ್ ಆರ್ ನಾಟ್ is a matter left to the domain of the appellate court.
Please.
Correct?
Yes. My lord, if the legislature provides such an occasion, my lord,
Correct.
discretion is bestowed with the court to condone the delay in this Land Acquisition Act.
ನಿಮ್ಗೆ ಸ್ವಲ್ಪ ಏನೋ ಸಮಸ್ಯೆ ಇದೆ ನಿಮಗೆ. This question arises only if there is a provision for condoning delay.
No such provision is there.
Even first year law student understands.
Yes.
Now assume that there is no such provision for condonation of delay. And court still condones it. Okay? How, where you should challenge it?
If I'm not wrong, that order suffers from error of jurisdiction. If
Therefore,
this point passed.
it has to be called, because 64 Supreme Court says a decree granted in a time-barred suit is not a decree without jurisdiction. Understand this. Read 1964 Supreme Court. A decree granted in a time-barred suit is not a decree without jurisdiction. Therefore, an order granted by the reference court in a time-barred reference cannot be said to be without jurisdiction. You can challenge it before in the appropriate hierarchy of the institutions, saying there is no provision for condonation of delay. He could not have entertained reference at all. That can be subject matter of challenge in MFA.
Please, my lord. With great respect, so far as the award is concerned, my lord, land acquisition provides for miscellaneous first appeal.
Correct.
So far as the reference order is concerned, my lord, no mechanism has been provided under the Land Acquisition Act.
So writ petition. So writ petition.
And in fact, the writ petition is concerned, my lord. Writ
No, how-
petition cannot be entertained against the judgment and order passed by the civil court, my lord. Usually, that's the normal practice, my lord.
But reference court is also civil court only.
It cannot be entertained, my lord.
Why?
And only against the order passed by the civil court, final order passed by the civil court.
On what basis you are making this submission?
Please, madam. On previous occasion, the society has approached this honorable court, challenging the order of the said reference, madam.
Correct. 227 the Lade Barado.
226, 227. That
26.
227. Please, madam. This honorable court, after considering all the factual and legal issues and referring to the decisions of the Honorable Supreme Court with respect to the fraud, misleading, misrepresentation, was pleased to set aside the order mail of reference court mail.
Correct.
That order was challenged before in the writ appeal mail.
Yes.
Writ appeal referring to Radhesham case, set aside the order passed by the learned single judge.
Yes.
Observing that, my lord, judgment and decree passed by the civil court cannot be the subject matter of jurisdiction.
Jurisdiction.
Please, madam. In those circumstances, subsequent to that only this OS was filed. And in the observation was also made by the division bench that in the appropriate forum, I have to ventilate the grievance.
That
order. And in fact, this on
order.
Please, my lord, I have not produced that order. And this honorable court was pleased to observe that the findings recorded in the order set aside by the division bench is of no use in of the settled position of the Bajaj case, referring to that Bajaj case.
Aspect to consider,
So, in the Chamundi Muppets Limited, and at page 34, para 9.
Order quashed and order stayed nadiviರೋ difference ಅನ್ನು maintain ಮಾಡಿ. ಆಮೇಲೆ ಏನಾಗ್ತದೆ? Order stay ಆದ್ಮೇಲೆ
Order was set aside by the single bench order was set aside. They have manipulated and obtained the order. They have manipulated. The government leader has filed the memo, my lord. And solely based upon that memo, order of reference was passed.
Yes, madam.
How Madhavan Housing Society itself has challenged the reference. Lord, those writ petitions have been dismissed in WP numbers 24,082 of 2022.
The order.
The order route in the
pass on,
review
madam.
petition hakidmel those orders have been passed.
Kindly pass.
ಅದಾದ್ಮೇಲೆ ಆಗಿದೆಯಾ?
May I pass?
Allah, Nagaratna madam judgment affirmed in Supreme Court,
It was set aside by the
My lord.
division bench headed by Justice K.L. Manjunath and
set aside. Then
Was-
matter went to SLP.
And
SLP
SLP was withdrawn.
SLP was withdrawn, seeking
Withdrawn.
liberty to ventilate the grievance before the appropriate forum.
1 second. So order of Madam Nagaratna is recalled, is set aside.
Set aside,
Set aside.
please.
Idenga, how this will cast its the shadow or light on this proceeding?
It will not cast any shadow on the so far the OS is concerned, my lord.
Allah, the review.
Please.
Review petition ಗೆ ಏನ್ ಸಂಬಂಧ ಪಡ್ತದೆ ಈ ಜಡ್ಜ್ಮೆಂಟ್ ಅಂತ?
Because my lord posed the question, my lord, whether we have challenged the reference order by filing the writ petition, my lord. For that, I have referred to the previous order passed in the writ petition.
ಈ ರಿಟ್ ಪಿಟಿಷನ್ ಅಲೋ ಆಗ್ಬಾರ್ದಿತ್ತು ಅಂತ ನೀವು ಹೇಳೋದು?
Writ petition allow ಆಗ್ಬೇಕಾ?
ಅಲ್ಲ,
ನಾನು
14483 of 2017,
please,
wherein you were respondent.
please, the society has prepared the writ petition.
You were respondent.
I am not the respondent. I am not the party to that
You
proceeding.
are not the party to this proceeding at all. But you are aggrieved by this order.
I am aggrieved, not this order passed by the writ petition, my lord. I am aggrieved by the order passed by the reference court. Both judge, reference court order as well as the award passed.
The award and reference code.
Yes.
Award and reference code.
Reference and award, both.
ಯಾಕೆ?
Reference is beyond the period of limitation.
Award.
Award is the consequential one. Whatever.
Award of the 18 award.
Fraud vitiates everything, foundation.
ಅಲ್ಲೆಲ್ಲಿ fraud ಇದೆ ಅಂತ?
In the reference court, the fraud was played by the government, pleaded by filing. Both, they have colluded with the landowner and filed the memo stating, even after, at that previous occasion, landlords have challenged the entire acquisition proceedings as well as the award. That writ petition came to be dismissed. As on the date of filing the writ petition, as on the date of dismissal of the writ petition, they were aware of they have the notice of award. So even after belated period, they have filed the reference application. To overcome the limitation, my lord, government advocate has filed, contrary to the normal practice in filing the memo in the civil court, in the open court, he filed it in the registry. Saying that the award amount was received on so and so date, hence the review reference application is well within the time of limitation. So based upon that memo, reference court has passed the reference order.
ಮೇಡಮ್ ಯಾವಾಗಾರ ಒಂದ್ ದಿವಸ ಇಲ್ಲಿ ಬರಕ್ ಆಗ್ತದಾ? ಇದೇನೋ ಕಾಂಪ್ಲಿಕೇಟೆಡ್ ಇದೆ ಇಶ್ಯೂ.
My lord, your lordship may have it next week. I will come.
That's what.
Because what has happened, all these issues have been decided already.
ಇವ್ರು ಹೇಳೋ ಇಶ್ಯೂ ಡಿಸೈಡ್ ಆಗಿಲ್ಲ, ನೋಡಿದೆ ನಾನು. Call this matter down next week, so that counsel appearing for
Respondent.
personally comes to court and argues. Full stop. Okay. But on the 64 Supreme Court ನೋಡ್ಬೇಕು. 64 Supreme Court says a decree passed in a time-barred suit is not an honest decree.
One set copy. Set copy of the.
ಕಾಪಿ ಕೊಟ್ಟಿಲ್ವಾ? ಕೊಡಿ, ಅವ್ರಿಗೆ ಒಂದು ಕಾಪಿ ಕೊಡಿ.
The Assistant Commissioner is also supporting. They have also filed the written statement saying that the fraud has been committed.
Committed
Contrary to the check-
OS ನಲ್ಲಿ.
In the OS, contrary to the check slip furnished by the Assistant Commissioner, the government pleader has filed the memo.
ಅವ್ರಿಗೆ ಒಂದು ಕಾಪಿ ಕೊಡಿ. Learned AGA on request accepts appears for response number 12 or 12 ಅಲ್ಲ?
Assistant Commissioner.
Assistant Commissioner or 12.
My lord, for the respondent in this matter, my lord. My lord, the petitioner has filed this review. Agreed by the order passed by this honorable court, wherein which this honorable court was pleased to allow the writ petition and directed the petitioner to issue possession certificate as concerned in the sale deed that has been issued to me, my lord. My lord, I have received the land from the petitioner in 1985. Consequent to that, my lord, on 11/12/2000, a sale deed is executed to the extent of 3,750 square feet, my lord. But they issue a possession certificate only to 3,145 square feet. To that extent, a possession certificate is issued.
It was less than what was allotted to you.
Yes, my lord. Being agreed by that, my lord, I had issued representations, which was not considered by the petitioner. Subsequent to that, my lord, I approached this honorable court. This honorable court, after hearing me, my lord, and
Directed consideration.
yes, my lord. And also, my lord, notice was served upon the petitioner. Notice, and also the petitioner had filed their wakalat. Despite which, my lord, there was no contentions that was raised by them, nor did they even enter appearance, my lord. Consequent to filing wakalat, they have not entered appearance. Now, my lord, in the review petition, their main ground is that the order passed by the Honorable High Court was placing them ex parte anta. That is their contention, my lord. My lord, the
Ex parte place Madela now.
yes, my lord. But yeah, this
Held served.
yes, my lord. But that is their main ground, my lord. If I may just take your lordship's attention, my lord, to page number 6 of the petition, my lord. Uh, 15th point, my lord. This honorable court would not have passed an ex parte order without providing an opportunity to the petitioner. Therefore, the order under the review petition is opposed to the principles of natural justice, my lord. My lord, this contention of theirs would have come to fore if in case, my lord, the court had passed an order without giving them an opportunity to be heard, my lord. In fact, in the original writ petition, my lord, sufficient time was granted to them. Despite which, my lord, they have failed to raise any objections, my lord. And my lord, all the grounds that they have raised in this petition, my lord, is something that can be raised in a writ appeal, my lord, not in a review.
Correct. This court, wide order dated 19/6/2024, having noted absence of the arguing counsel for the review petitioner, had said as under. Next part. When the matter was taken up this day for consideration, again the counsel appearing for the petitioner is absent, and there is none to represent case of the petitioner. First, endlessly, court cannot keep on adjourning the matters merely because counsel for the parties are not present. First stop. Next paragraph. Learned counsel appearing for the respondent draws attention of the court to paragraph number 3 of the review petition, two and three. 2, 3, 4. Two, 3, and 4. Draws attention of the court to the contents of paragraphs 2, 3, and 4. First stop. Come on, which read as under. First stop. The review petitioner's version that the order whereby the subject writ petition has been disposed of universally came to be passed, without providing an opportunity to the respondent stroke review petitioner to plead their case inwards complete is untrue, if not false. Full stop. Non-availment of opportunity given, is one thing. Not affording an opportunity is another. First, case of the petitioner fits into the former. ನಿಮ್ ಸೂಟ್ ಏನಾಯ್ತು?
My lord, it is pending, my lord.
ಸೂಟ್ ಏನಂತ ಇದೆ ಅದು?
Adina pending ಇದೆ, my lord.
ಎದಕ್ಕೆ ಅದು?
My lord, the dispute is between what the petitioner states is that, my lord, there is a common wall, but that is actually encroaching into our boundary. But their statement is that, my lord, that it actually is part and parcel of the canteen owners ಅವ್ರದ್ದು ಬರುತ್ತೆ ಅಂತ. So that has been pending.
ಒಂದು ಸೆಂಟೆನ್ಸ್ ಆದ್ಮೇಲೆ ನಿಲ್ಬೇಕು.
Yes, ma'am.
ಆ ಸಬ್ಜೆಕ್ಟ್ ಮ್ಯಾಟರ್ ಆಫ್ ಸೂಟು ಈ ಪಿಟಿಷನ್ ಬೇರೆ ಬೇರೆನಾ?
Yes, my lord.
Next paragraph. The contention taken up at second part of para 3 of the review petition about fraud allegedly committed by the respondent herein, that is writ petitioner, lacks material particulars. First, the version that the subject matter of the writ petition and that of the suit allegedly filed by the respondent are one and the same, cannot be examined in the absence of the pleadings in the said suit being, copies of the pleadings in the said suit being produced. First of all, fraud is a serious matter. First of all, therefore, full particulars as to who, when, and how it has been perpetrated need to be pleaded. First off, that has not happened in this case. Similarly, contents of para 4 that the petitioner, writ petitioner, who is respondent herein, has suppressed material facts, has also not been fully pleaded, has not been pleaded with full material particulars. OS 99 of 2015 ಏನು?
My lord, that was filed with regards to the same, with our dispute on that boundary, my lord. Subsequent to that, my lord, we have filed another RA, my lord, RA number 21 of 2020, wherein, my lord, we have taken the contention as to that the exact extent that has been actually, that has been given to us is as per the sale deed.
ಅದಕ್ಕೇನಾಯ್ತು ಆರಕ್ಕೆ?
ಅದು RA is still pending, my lord. That is still pending.
ಎಂಟ್ರಿ ಮಾಡಿದ್ಯಾ?
My lord, I will have to seek instructions on that aspect. My lord, my lord, my humble submission before this court is that, my lord, in the very first occasion when the sale deed was executed in my favor, my lord, in 2000, my lord, the complete extent that was given to me as per the possession certificate, as per the sale deed is, my lord, to the 3,750 square feet, my lord. In that first occasion, my lord, when there was no dispute with regards to the extent, my lord, and only when I seek a representation, they come up with this saying that there is a dispute on this, my lord. Up until then, my lord, there is nowhere.
ಒಂದ್ ಸೆಂಟೆನ್ಸ್ ಆದ್ಮೇಲೆ ನಿಲ್ಲೋ ಪದ್ಧತಿನೇ ಇಲ್ಲನ.
Sorry, my lords. Sorry,
ಒಂದ್ ಸೆಂಟೆನ್ಸ್ ಆದ್ಮೇಲೆ ನಿಂತ್ಕೊಂಡು ಈ ಸೆಂಟೆನ್ಸ್ ಮೇಲೆ ಜಡ್ಜಿಗೆ ಏನು ಇಂಪ್ಯಾಕ್ಟ್ ಆಗ್ತಾ ಇದೆ ಅದೇನಂತ ಕಲ್ತಿಲ್ಲ ಏನು?
I'm sorry, my lord.
ಈಗ ಹೆಂಗ್ ನಾವು ಲಾಯರ್ ಮೇಲೆ ಬರೆಯೋದು ಹೆಂಗೆ? ಶಿ ಇಸ್ ಅ ಪ್ಯಾನಲ್ ಕೌನ್ಸಿಲ್ ಬೇರೆ.
Yes, my lord, but my submission is.
ಏನ್ ನಿಮ್ಮ ಅಬ್ಸೆನ್ಸ್ ಮೇಲೆ ಅವ್ರ ಮೇಲೆ ನಾವು ಹಂಗೆಲ್ಲ ಬರೆದ್ರೆ ನಾಳೆ ಅವ್ರನ್ನ ಕಿತ್ತೋದ್ರೆ ಏನ್ ಮಾಡ್ಬೇಕು ಅವ್ರು?
My lord, but what
ಲೇಡಿ ಬೇರೆ ಮತ್ ಮೇಲೆ.
Yes,
ಬರಕ್ ಹೇಳಿ.
ಪ್ಯಾನಲ್ ಅಲ್ಲಿ ಇದ್ದಾರೋ ಏನೋ
ರಿಕಾಲ್ ದಟ್ ಆರ್ಡರ್. ಏನಪ್ಪ?
And in fact, my lord, they are still in contempt of your lordship's order, my lord. We have even filed a contempt petition.
ನೀವು ಫೈಲ್ ಮಾಡಿರಾ?
Yes, my lord.
ಅಲ್ಲಿ ತಗೊಳ್ಳಿ, ಅಲ್ಲಿ ಬಿಸಿ ಮಾಡಿ ಅವ್ರು ಬರ್ತಾರ ಅವ್ರು ನಮ್ಮ ಬಂದಿಲ್ಲಿ. ಇಲ್ಲಪ್ಪನ್ ಬರಲ್ಲ ಅವ್ರು. This court wide order dated 19/6/2024 had said as under. Next paragraph. When this matter was taken up this day again and the court was dictating the judgment, it felt that one more opportunity needs to be granted to the review petitioner. First, in view of that, call this matter next Friday. Then
I will inform the department. Small scale industry, I will inform the department.
Yes. Yeah, next Friday. Next week ಅಂತಾನೆ ಫ್ರೈಡೆ ಬರ್ತದೆ. ಮಾಡ್ಬೋದಾ? ಅವ್ರಿಗೆ ಹೇಳಿ ನಿಮ್ಮ ಮೇಲೆ ಏನೋ ಬರೆಯಕ್ ಹೊಟ್ಟಿದ್ರು ನಾನು ನಿಲ್ಸಿದ್ದೇನೆ, ಬರೀ ಕೋರ್ಟ್ ಮುಂದೆ ಹೇಳಿ.
I once again apologize.
ಪ್ಯಾನಲ್ ಕೌನ್ಸಿಲ್.
Yes, ma'am.
ಈಗ ನಾವೇನ್ರ ಬಂದು ನಾಳೆ ಪ್ಯಾನಲ್ ಇಂದ ರಿಮೂವ್ ಮಾಡಿದ್ರೆ ಏನ್ ಮಾಡೋದು?
I apologize once again, my lord.
ಯಾವಾಗೂ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡುವಾಗ ಬ್ರದರ್ ಒಳ್ಳೊಳ್ಳೆ ಪುಸ್ತಕ ಓದ್ಕೋಬೇಕು. ಆರ್ಟ್ ಆಫ್ ಆರ್ಗ್ಯುಮೆಂಟ್ ಬೈ ಜೆರಾಲ್ಡ್ ಅಂತ ಒಂದಿದೆ. ಯಾವ ರೀತಿ ಆರ್ಗ್ಯೂ ಮಾಡ್ಬೇಕು, ಸೆಂಟೆನ್ಸ್ ಹೆಂಗ್ ಕನ್ಸ್ಟ್ರಕ್ಟ್ ಮಾಡ್ಬೇಕು, ಎಲ್ಲಿ ಪಾಸ್ ಕೊಡ್ಬೇಕು, ಮಾಡ್ಯುಲೇಷನ್ ಆಫ್ ವಾಯ್ಸ್ ಹೆಂಗ್ ಮಾಡ್ಕೋಬೇಕು, ಎಷ್ಟೆಲ್ಲ ಚಂದ ಬರ್ದಾನ ಒಬ್ಬ ಮುಫುಜಿ ಲಾಯರ್ ಇನ್ ಅಮೆರಿಕಾ, ಒನ್ ಆಫ್ ದ ಬೆಸ್ಟ್ ಲಾಯರ್ಸ್. ಪಾಸ್ ಬೇಕು, ಸೆಂಟೆನ್ಸ್ ಆದ್ಮೇಲೆ ನಿಲ್ಬೇಕು. ಅವಾಗ ಕೇಳುಗಗೆ ಹೇಳುವನ ಬಗ್ಗೆ ರೆಸ್ಪೆಕ್ಟ್ ಬರ್ತದೆ.
Yes, ma'am.
ನಂಗೆ ಅಪರ್ಚುನಿಟಿ ಕೊಡ್ತಾ ಇದ್ದಾನೆ ಅಸೆಸ್ ಮಾಡ್ಲಿಕ್ಕೆ, ಶುಡ್ ಹಿಯರ್ ಹಿಮ್ ಮೋರ್ ಹಿಂಗ ಅನಿಸ್ತದೆ.
Yes, ma'am. Okay.
Sorry.
I'm appearing for respondent.
ಎಲ್ಲಿ ನಿಮ್ಮ ಫ್ರೆಂಡು ಬರ್ತಾ ಇಲ್ಲ? ಇನ್ನಿನ್ ಡೇಟಿಗೆ ಏನು ಹಾಕಿರಿ?
Last time ಬಂದಿರ್ಲಿಲ್ಲ.
Finally, next week, to enable counsel for the review petitioner to come and argue. Okay.
Please.
ಇನ್ನೊಂದಿದೆಯಾ? ಇದೇನ್ರಿ ಮ್ಯಾಟರ್ ಪರ್ಟೈನಿಂಗ್ ಟು ಧಾರವಾಡ ಬೆಂಚ್. EP.
My lordship. I appear for the petitioner, my lordship. The honorable court is pleased to give me opportunity to do the office objection, my lordship. Comply the office objection, my lordship.
ಮೆಮೊ ನೀವು?
ಅವೆಲ್ಲ ಕಂಪ್ಲೈ ಮಾಡಿದೀನಿ, my lordship. ಮಾಡಿ ಆಗ ಮೆಮೋಸ್
ಕಂಪ್ಲೇಂಟ್ಸ್ ಆಗಿದೆಯಾ? Counsel for the election petitioner submits that office objections having been complied, comma, the 3 memos dated 26/9/2024, 15/10/2024, ಇನ್ನೊಂದು ಡೇಟ್ ಏನು?
ಅದೇ 26 ಅಲ್ಲಿ 2 ಹಾಕಿದ್ವಿ.
ಅಲ್ಲಿ ನೋಡಮ್ಮ, 2 memos dated 26/9/2024 and 1 memo dated 15/10/2024 be disposed of as having not been pressed.
My lord. ಅದ ಆಫೀಸ್ ಅದ ಒಂದು 83 ಕೇಳಿದ್ರು ಮೈ ಲಾರ್ಡ್ಶಿಪ್. 83 ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಕೇಳಿದ್ರು ಮೈ ಲಾರ್ಡ್ಶಿಪ್. 83 ಸೆಕ್ಷನ್ ಅಲ್ಲಿ ಅಬ್ಜೆಕ್ಷನ್ ರೈಸ್ ಮಾಡಿದ್ರು. ಅದಕ್ಕೆ ಆಫೀಸ್ ಸಬ್ಮಿಷನ್ ಕೊಟ್ಟಿದೆ ಮೈ ಲಾರ್ಡ್.
Issue notice keeping open the latest office objection dated.
ಲೇಟೆಸ್ಟ್ ಅಲ್ಲ ಮೈ ಲಾರ್ಡ್, ಮುಂಚೆದೆ ಅದು. ಅದನ್ನ ಆಫೀಸ್ ಸಬ್ಮಿಷನ್ಸ್ ಕೊಟ್ಟಿದ್ದೀನಿ.
Office objection in relation to pleadings as to section 83 of RP Act.
Yes, my lord. Submission has been given, my lord.
ನೋಡೋಣ, ಕೀಪ್ ಓಪನ್ ಮಾಡೋಣ.
ಸೀನಿಯರ್ ಕೌನ್ಸಿಲ್ ಬರ್ತಾರೆ ಮತ್ಲ.
ಅದು ನೋಟಿಸ್ ಹೋಗ್ಲಿ.
ಮೇಡಮ್
ಏನ್ ಯಾರು ಬೇಕಿಲ್ಲ ನೋಟಿಸ್ ಹೋಗ್ಲಿಕ್ಕೆ, ಅಲ್ಲ ಎಂತದು ಬೇಡ. ನೋಟಿಸ್ ಹೋಗ್ಲಿ ಮೇಡಮ್, ನೋಟಿಸ್ ಹೋಗಿ ಬರ್ಲಿ. ಅದೇ ಎಸ್. ಏನಂತೆ? ಹೌದು, ನೋಟಿಸ್ಗೂ ಡೇಟ್ ಫಿಕ್ಸ್ ಮಾಡಕ್ಕಾಗತ್ತಲ್ಲ. ಇಶ್ಯೂ ನೋಟಿಸ್ ರಿಟರ್ನೇಬಲ್ ವಿದಿನ್ 2 weeks, fixing next date of hearing to be Monday.
In last 3 weeks has to be given, my lord. 3 weeks time ಕೊಡ್ಬೇಕು.
ಅದೇ 3 weeks. 3 weeks.
And my lord,
3 weeks. Under the rules itself 3 weeks ಇದೆ.
then my lord, the notice must be for filing the written statement. That's the rule.
3 weeks. For filing of written statements.
Yes, my lord.
First stop. Call this matter. Order madam. Issue. ಅಲ್ಲ 2 years ಆಗಲ್ಲ ಅದು. Issue emergent notice to the respondents. Full stop. Call this matter 3 weeks ಆದ್ಮೇಲೆ ಆಗ್ಬೋದು. 13th of December 2024. In the meanwhile, written statements to be filed by the other side if so desired. Okay.
Yes.
13-12 ಮಾಡ್ಬೋದಾ?
ಆಗ್ಬೋದು.
Okay. Fine.
Much obliged. ನೀವು ಅಡ್ವೊಕೇಟ್, ನೀವು ಅಡ್ವೊಕೇಟ್, ಅಡ್ವೊಕೇಟ್ ಆಗಿ ಇದು ಯಾವುದು ಶಾರ್ಟ್ ಹ್ಯಾಂಡ್ ಬರುತ್ತೆ.
ಆಯ್ತು ಸರ್, ಆಯ್ತು. ಅಪ್ಪ 5 ಮನೆ ಡೆಮಾಲಿಷನ್ ಬಂದ್ಬಿಡ್ತಾರೆ BBMP. 2:30 ತರ್ಬಿಟ್ಟು 3 ಗಂಟೆಗೆ ತರ್ಬೇಕು. ಅಮೃತ ಮಾತ್ರ ಸರ್. ಬಟ್ ಒಂದು ಏನ್ ಮಾಡ್ಬಿಟ್ಟಿದೀನಿ, ಇದು ಹ್ಯಾಂಡ್ ಕೊಡಿಯೋದು ಏನೋ ಅಲ್ಲ, ನಾನು ಹೇಳು ಸೀನಿಯರ್ ಸಂಪಾದನಾ ಶೆಟ್ಟಿ ನಿಲ್ಸಿದ್ವಿ. ಸಾಹೇಬ್ರ ಕೇಳಕ್ಕೆ ಭಯ, ಸಿಕ್ಕಾಪಟ್ಟೆ ಭಯಂಕರ ಇವತ್ತು ಏನು ಮೂಡೋದಿಲ್ಲ. ಇಲ್ಲಾಂದ್ರೆ ಬೆಂಚ್ಗೆ ಇವತ್ತು ಆಗ್ಬೋದಲ್ಲ ಸರ್? ಥ್ಯಾಂಕ್ ಯು. ರೈಟ್ ಸರ್,
ಥ್ಯಾಂಕ್ ಯು ಸರ್. 13-12ಗೆ ಪೋಸ್ಟ್ ಆಯ್ತಲ್ಲ ಸರ್? ಅವತ್ತು ಸಾಹೇಬ್ ಇಲ್ಲಿರ್ತಾರ ಧಾರವಾಡ ಸರ್? ಧಾರವಾಡ ಸರ್ ನೆಕ್ಸ್ಟ್.